Hello, everybody. Oh, somebody heard me. Hi, baby girl. Yeah, you come up off the bed out there. Yeah, get some early treats. Get the pretty girl. So I got this out. It was a yard sale find from a while ago. It's a true percolator. Like, it's got this wine glass shaped looking thing inside of it, and it's got the drip canister in it, and the water bubbles up through the straw in the middle. And so I decided to brew a pot of coffee on it. It's not as strong as I would like. I'm going to have to learn the ratio, the proportions, and the time, and how long to let it rest. But I think it's going to serve me well. My mom always swore that percolated coffee was the best. And so did this gentleman that I lived with when I was a teenager. Helped take care of him. Ava. Yeah, one more, baby. Helped take care of him, and he had one of those church percolators, the giant ones, and every morning we would make a pot of coffee in Big Bertha, is what he called it, and we would drink it for half the day and then make another round. My love of coffee goes way back, way back. So I'm drinking it out of my A Drunk Man's Words or A Sober Man's Thoughts mug. Yep. Except I don't have to press anything. Yeah, so I'll figure it out. I'll get it figured out. Today I learned I'm a dummy. I was walking past my thermostat and I realized I had the heat on, which was tragic because I had my windows open all night. So, yeah. And then I went to go to the bathroom, and apparently I need to replace the flapper in there because it was just, God only knows how long it was running. So I'm having a day, guys. I'm having a day. Since the internet went down last night, it's been one thing after another. But I'm here, and that's the most important part. I'm here with people that I love. People that make me oh so super happy. I'm having Charlie horses really bad. From my doctor doubled my atorvastatin, and I don't know if anybody else is familiar with statin drugs, but they can cause muscle cramps. Yeah, it's one of the commonly known side effects of statins. And I've been having like small Charlie horses here and there, and now it's to the point where like my calves are just one solid muscle cramp that won't release. So I'm gonna have to go off of it for a little while, or decrease the dose back down to what it was. Yeah. I emailed her about it. I'm like, hey, I can't take this. Part of it comes from not being able to walk much, but But the other part, the other part is the atorvastatin. So please take me off of it. So, anyways, that's my day. That's how things are going here at the Paw Firm. Hello, Buzzy Pug. Yes. Well, internet went down last night and I couldn't stream the docket. So, which meant I have no replay crew minis to put up because I couldn't stream. So, yeah. So I have to run something. And I'm here. I'm here with a smile on my face. Hello, Nana Laura, sweetie. Hello, Eileenie, Carolyn, honey. Your secret's out, but it's safe with me. That's only 2 days away. Thank you so much, honey. Hello, Rocky Lennon. Hello, Charlie. Good. Yeah, the internet's been goofy. It's not. I had to reset my modem and router this morning because I had no internet still at 8 o'clock. And I'm like, I need to start downloading dockets. Like, when am I going to get internet back? And I checked the Spectrum site and it said that internet had been restored. So I rebooted and then I finally had it. But yeah, dockets start populating at like 7:30 here. So I was a little annoyed when I still didn't have internet by 8. I don't see every message, but I saw that. If I see the word secret, I'm gonna stop. All right, so we're gonna start the whole thing over. We were only like 20 some minutes into it anyways. And now we know to watch that girl in the back middle. Yeah, because there's some shenanigans afoot with that one. I missed it during editing. Like I didn't see everything she was doing. But then when we saw it last night, she was doing the most. So I like the theory someone came up with last night that she's trying to pass him something. I like that theory. I think that might be accurate. They definitely seem very chummy. Hopefully my internet will stay up.
We'll handle our preliminary matters first, and we'll start with Michael Slavicki, excuse me.
Morning, Your Honor.
Good morning, Mr. Slavicki. How are you?
Oh, I'm doing a little better than last night.
Good. I'm pulling up your case. Just give me 1 second, please. There we are.
I know.
Sir, did you watch the video this morning that contained your constitutional trial rights?
I understand it. I've memorized it, so I understand.
Yeah, you probably can recite it at this point. You understand all your rights, sir?
You understand your rights, sir?
Yes, sir.
Did you have enough time to speak with Ms. Burning, your lawyer, this morning?
Yes.
We're on record in 25 CR 10880. In this case, you were charged with drinking or possessing an open container of alcohol in public. This alleged to have occurred on July 24th of this year in the area of 6135 South Virginia Street. Do you understand that charge?
Yes, sir.
It alleges you failed to appear to answer to that charge. That failure to appear alleged to have occurred on July 31st of this year. First, do you wish to admit or deny failing to appear on July 31st?
No, it's a failure.
Hang on just 1 second. I have a warrant for a different date. I have a warrant for August 6th. Ms. White or Ms. McTeer, why do we have a different date? Were we closed on that date? And I'm looking at the citation and it does have them on a July 31st. I'm going to go ahead and quash that warrant. How do you wish to plead to the open container charge, sir?
Contest, Your Honor.
You understand that by pleading no contest this morning, you'll be waiving the rights you understand your criminal trial rights? Do you understand that?
Yes.
I'll accept your plea of no contest, find you guilty. City?
Your Honor, we've had Mr. Slibicki several times in community court. He's an individual who frankly needs help. This is his 6th case that we've had with him in RMC in 2025 alone. That stated, Judge, I don't have a lot of further information. I'm going to defer to Your Honor with regard to an appropriate sentence here.
All right, thank you. Ms. Burning?
Your Honor, Mr. Slivicki has been in custody for 3 days. I would be asking for credit for time served.
All right, thank you. Mr. Slibicki, anything you want to say before I sentence you? You're not required to say anything, but you are welcome to.
Sure. I would never go to, that would ruin everything.
Yeah, I'm sorry, say again. I didn't hear the first
Ruin my life
part.
If I had to do that, I'm sorry, Your Honor, it would ruin my life if I had to do that. So I think I'm going to leave Reno and go somewhere else now.
Okay, well, I'm not going to make a comment on that, but I'll tell you that alcohol has been interfering with your life for a long time. We tried to help you at community court. That was to no avail. I'm going to place you on a suspended jail sentence, and it's a jail sentence that I will be willing to revoke if you reoffend. I'm telling you, I won't hem and haw. I'll just revoke it. You'll do the time. It's that simple. Because of the many violations you've had, 30 days Washoe County Jail, suspended, 1 year. You will obey all laws, no alcohol or drugs without a prescription. You violate either of those clauses, you're going to jail for that 30 days. Thank you.
Thank you. What would the suspendence, it's 90 or 30?
30.
All right.
Lorenzo Moreno?
Yes, sir.
Mr. Moreno, good morning. We have 3 matters with you.
Okay.
Let me take a look here. First, I'm going to alert you to a suspended sentence, and I'd like to ask you first, did you watch the video this morning that contained your constitutional trial rights?
Yes, Your Honor.
You understand the rights and the penalties associated with misdemeanors and contempts of court?
Yes, Your Honor.
And did you have sufficient time to speak with Ms. Burning, your lawyer?
Yes, Your Honor.
25 CR 06501, Department 1 imposed 120 days in the Washoe County Jail back on May 28th of this year. He suspended that sentence for 2 years. Conditions: obey all laws, no alcohol or drugs without a prescription, and then follow the substance use evaluation on off-site. It was to run concurrent with another case that was active at the time, but I don't have record of that case. I do want you to know that if you're found in violation, or excuse me, if you're convicted of any of these new charges, you could be found in violation of that suspended sentence and have to serve that time. Do you understand that?
Yes, Your Honor.
Let's go on record on your new cases. 25 CR 14123, you were charged with sitting, lying, camping, or sleeping, and littering charge. These were alleged to have occurred on September 17th of this year. Just 1 second. And this was in the area of Neal Road. Do you understand both of those charges?
Yes, Your Honor.
You were required to appear on those charges on September 24th, but allegedly you failed to appear. Do you wish to admit or deny failing to appear on September 24th?
I didn't go, Your Honor.
I accept your admission. I will find you in contempt for that. Let's go to the other case before we decide what to do on that matter. 25 CR 15051. In this case, you were charged with use or possession of drug paraphernalia. You were arrested for this. Alleged to have occurred on October 9th in the area of 3925 Neal Road. Do you understand that charge?
Yes, Your Honor.
How do you wish to plead to that charge, sir?
Guilty, Your Honor.
Do you understand that by pleading guilty to this or any other charge, you'll be waiving the trial rights you heard in that video?
Yes, Your Honor.
You understand that means there will be no trial in this case and we'll proceed directly to sentencing.
Yes, Your Honor.
I'll accept your plea of guilty. Ms. Janelle, which other charges would you like me to canvass on this morning?
Judge, with his plea to the paraphernalia, I'm going to make a motion to dismiss the case 1, 2, 3.
All right, got it. That'll be the order. The sitting, lying, camping, or sleeping, and the littering will be dismissed pursuant to the plea to the paraphernalia. Would the city have arguments regarding sentencing?
I do, Judge. If I may seek some clarification from your court staff in the 501, the revocation case, I don't see a substance abuse evaluation. Presumably one was done, though, because he was referred to COD court and ultimately not accepted. Do we have a substance abuse evaluation by chance?
Just 1 second. I don't think so, but let me look. And I'll ask my staff will know better than I, but I'm gonna look at that case as well.
And that's 6501, is
Yes,
that
ma'am.
correct?
Yes, and what I have is defendant was ordered to report release on that case and failed to do so. Although that was on Judge Draculich's order of the 120.
Mhm.
Never mind.
I do not see an eval done on this case.
All
Thank
right.
you. So if I may inquire of Ms. Burning then, given that we have a subsequent paraphernalia, I have concerns of the ongoing issues. And the paraphernalia, law enforcement indicates he has chronic issues with drug use in the park. When they made contact with him, it was pretty apparent that he was impaired. He admitted to recently smoking methamphetamine. So I inquire about his willingness to remain in custody pending an evaluation and potential referral to an inpatient facility.
Let me inform the court that that's not where my client's at right now as far as what he wants to do.
Okay.
He's been in jail for 5 days, and I would be asking for credit for time served on his behalf.
All right, thank you. Given that information, Ms. Ginoli.
Judge, given that information that he's unwilling to help himself, he continues to be a chronic offender and user of drugs in the parks where children are present. I'm asking you impose time served on the paraphernalia and revoke the 120-day suspended sentence.
All right, thank you. Ms. Burney?
Nothing further, Your Honor.
Mr. Moreno, anything you want to say before I sentence you?
No, thank you, Your Honor.
Time served on the new paraphernalia charge. I'm revoking, finding you in violation of the suspended sentence in 25 CR 06501. I'm revoking you to the 120 days. That's also in light of the fact that you didn't follow through with that case at all. So that case will be closed, revoked, and you won't have that hanging over your head after you serve that jail time. Thank you.
You wouldn't think it by looking at him, but this judge is actually kind of a hard ass. It's refreshing. I like it.
Next matter I have is Joshua Hara.
How you
Mr.
doing,
Hara,
Your Honor?
good morning. Fine, thank you.
Hi,
Mr.
sir.
Hara, did you watch the video this morning that contained your rights?
I sure did, Your Honor.
Great. Did you understand the rights as well as the penalties associated with misdemeanors?
Yes.
Great. And finally, did you have sufficient time to speak with your lawyer, Ms. Burning?
I talked to her for a minute. I did, sir.
All right. If you need more time while we go through this, you let me know. I'm going to put us on record in 25 CR 15076. Let me pull up your case on my computer here as well. Just 1 second, please.
Can I say one thing to you at least? sir?
Yes.
I was at my house sitting in my room.
I'd advise
No.
against this.
Absolutely not. Don't speak about the facts of the case, please.
Okay.
And don't speak about, if you have a question relative to that, you need to ask your attorney. So let me put us on record in 25 CR 15076. You were charged with the crime of assault, excuse me. This was alleged to have occurred on October 9th of this year in the area of North Virginia Street. Do you understand the charge, sir?
Yes, sir, Your
How do you
Honor.
wish to plead?
I would say, I was in distress
So
and
how,
got shot at
how do you wish to plead, sir?
and ended up spitting in front of a security guard. And she
So
said,
you're making admissions on record that
Not
can be
guilty.
used against you if you
Not
set
guilty.
this for trial. You are to remain silent, and that goes to everyone in this courtroom. It is in your best interest. You have a right to remain silent as to the facts of your case. I encourage you to remain silent.
You just admitted to what you did and then said not guilty. That probably not going to work in your favor.
I'll enter that not guilty plea. You will have counsel appointed to represent you in this case. Bail has already been set in the amount of $3,000 bondable. You are to stay away from North Virginia Street. Let's get a bench trial date.
It'll be November 20th at 8 a.m.
November 20th, 8 o'clock in the morning is your bench trial date, sir. We'll see you on your trial date. Thank you.
Judge, if I may ask, just procedurally speaking, I have notes that indicate he refused bail hearings on Saturday, so I don't know if bail
I
hearings.
apologize.
I could
Thank
be
you.
mistaken.
And all right, do we have record of that? I have bail set, but I don't have anything else. Typically, that's a bail hearing on the 11th, but Ms. Ginoli could be right.
It looks like he refused.
Let's have a bail hearing then. Ms. Ginoli, thank you.
You're welcome, Judge. Your Honor, here it appears that the defendant was at the Silver Legacy. He was trespassed, he refused to leave, and he spit at the security officer, female security officer in the reporting party. When they made contact with her, she indicated that she had asked him to leave. He spit at her. He then made a gun gesture towards his head, indicating that he was going to harm her. She called 911 and he again spit in her direction. His risk is high, Judge, at A10. Criminal history is 33 pages in length. We have concerns for community safety given the allegations in this case. I believe the holding bail is $3,000 bondable, if memory serves me right. I'm asking for the continued imposition of that. Conditions should he be released that he obey all laws, consume no alcohol or drugs, and stay away from both the tri-properties as well as the alleged victim, Ms. Vega, in this case, please.
All right, thank you. Ms. Burning, please.
Your Honor, this is an assault charge. This isn't a murder. And I would be asking for bail in the amount of $1,000 bondable.
Mr. Hara, anything you wish to say only regarding your release from custody, not about the facts of the case? You're not required to say anything if you don't wish to.
I just say thank you, Your Honor.
All right, thank you. Bail will be set in the amount of $2,000. It'll be a bondable bail set. Conditions, should you make that bail, or that you will bail laws, you will neither consume nor possess alcohol or drugs without a prescription. You will stay away from row properties. We'll see you on your bench trial date. Thank you. Next matter I have is Adam Hawthorne. Mr. Hawthorne, good morning.
Morning.
We're on record in 24 TR 08194. In this case, arrest warrant issued for you. It alleges you owed fines in the amount of $942 that were due on or before March 14th of this year, but you failed to pay those fines when due. Do you wish to admit or deny that warrant?
I admit.
I accept your admission and I will find you in contempt. Ms. Burning, please.
Your Honor, first of all, I tell the court that it is failure to pay fine of $942 that my client had other matters that he was trying to take care of, and he didn't have work at that time. I would be asking for 5 days credit for time served to be taken off of the $942 that he owes, and that he be allowed to make payments if there is any additional fine left.
All right, thank you. Mr. Hawthorne, anything you wish to say before I make my decision of how to proceed on this?
No.
Why didn't you pay the fines when due? Why didn't you come to the court and ask for extension of fines?
I do believe I was incarcerated already. I've been incarcerated 3 times, and I figured that this ticket has been taken care of. I came once, I did a 90-day violation.
Oh.
Then I came back and I did 2 weeks, and I recently just got out April, and I did 80-something days. So them 3 times I figured that the ticket was taken care of, but I never knew.
That makes sense. That makes sense to me. All right. Are you working?
Yes.
What kind of work do you do?
Material handler at USA Parkway.
Good. I want you to get back to work. I'm going to release you. You are ordered to report, time served on the warrant, ordered to report on release to the Reno Municipal Court. You will pay these fines, and you'll set up a payment plan for those fines. Make sure you get to court. If you can get here by 5:30 today, do so. If you can't, tomorrow's fine. All right?
Thank you.
Thank you, sir. And then Antonio Reese. Mr. Reese, good morning.
Good morning.
Mr. Reese, did you watch the video this morning that contained your constitutional trial rights?
Yes, I did.
And did you understand both the rights and the penalties associated with misdemeanor charges?
Yes, sir.
Did you have sufficient time to speak with your lawyer this morning, Ms. Burning?
Yes.
We're on record in 25 CR 14958. You were charged with the crime of domestic battery, a first offense. This alleged to have occurred on October 2nd of this year in the area of Leadership Parkway. Do you understand that charge?
Yes.
How do you wish to plead?
Not guilty.
I accept your plea of not guilty. The matters have been reviewed for probable cause and appointment of counsel. You will have an attorney representing you in this case. Let's get you a pretrial conference date.
That'll be November 20th at 8 a.m.
I have November 20th at 8 o'clock in the morning. Now I have that bail was originally set at $3,000 on October 8th, but I don't know if, given the fact that we're here now, I'm not sure if we had a bail hearing on this matter. Does anyone have any information relative to the whether bail hearing of Valdez Jimenez hearing was held?
Judge, go ahead.
I'm sorry, Ange. Go ahead.
No, you go ahead, Rosie.
It just looks like he was in intake and then uncooperative last week.
That's what I figured. Yeah. So let's go ahead and have a bail hearing, and there was not one this weekend as well. So, Ms. Giannoli.
Thank you. Your Honor, here it looks like the parties are in a dating relationship. The two were arguing while driving in a vehicle. The defendant got upset at the victim and punched her in the face, leaving a bruise to the inside of her lip and scratched her right hand. It appears that roommates were also involved. Roommate was called and words were exchanged between the defendant and the roommate. And the defendant ultimately threatened the victim with a gun, but the victim indicates the defendant doesn't have a gun, so she's not concerned about that. His criminal history is 28 pages in length, Judge. His criminal history is concerning. It also appears that he is being held in the RJC for a felony eluding as well as a probation violation in the Second Judicial District Court. His risk is high at a 9. 28 pages of criminal history. Most recently, he was convicted of pandering, pled or found guilty, spent 1 to 4 years in prison. I suspect that's probably the probation violation, the Second Judicial. In 2021, he was arrested for a domestic battery as well as a child abuse. Those candidly were ultimately dismissed. In 2014, arrested for a grand theft, which was reduced to a forgery. In 2009, he had a slew of cases that were ultimately globally resolved. It was a possession of a controlled substance while in possession of a firearm, felon in possession of a gun, probation violation and carry a concealed weapon. Those were dismissed with his plea to a possession of cocaine for the purposes of sale. In 2007, he was guilty of transporting a controlled substance. The remainder of his criminal history, Judge, is juvenile in its it is juvenile related history. That stated, Judge, I believe the continued imposition of the $3,000 bondable is appropriate in this case. I'm asking conditions should he be released that he obey all laws, consume no alcohol or drugs, and have absolutely no contact with the alleged victim, Ms. Zimmerman, in this case, please.
All right, thank you. Ms. Burning, please.
Yes, my client has a place to live. He does have work. And what I would be asking for, Your Honor, is not a bail of $3,000, but a bail of $1,500 bondable on this. He does have a felony matter that is pending. So he has a lot to lose by not showing up to court. For those reasons, I ask for the reduced bail.
All right, thank you. Mr. Reese, anything you wish to say relative to your release from custody, not about the facts of the case, and you're not required to say anything if you don't wish to.
No, I don't got anything to say, sir.
All right, thank you. The city, I find, has met their burden under Valdez Jimenez, showing by clear and convincing evidence the need for bail, that non-monetary conditions themselves will not suffice. That's in light of the significant criminal history and this particular case here. The facts alleged. Bail will be set in the amount of $3,000. It will be a bondable bail set, and I find the following conditions to be the least restrictive means at ensuring that the victim and the community stay safe and that Mr. Reese attends his court appearances. Obey all laws, no alcohol or drugs without a prescription, and you will have no contact with Tylee Zimmerman. Violation of that pretrial no contact order is both contempt of court as well as a new misdemeanor crime. We'll see you on your trial date. Thank you, sir. Oh, excuse me. Did we get a pretrial on that?
Yes, Judge, it
Yeah,
was.
11:20. Thank you. Thank you. Matthew Bach. Good morning. Mr. Bach, you have 4 cases with us, one of which is a new case. Did you watch the video that contained your rights this morning?
Yes.
Did you understand the rights and the penalties associated with both misdemeanors and contempts of court?
Yes.
Did you have sufficient time to speak with your lawyer, Ms. Burning?
Yes.
Let's go through your matters. First, I'm going to let you know that I issued a suspended sentence back on August 18th of this year. I imposed 45 days in the Washoe County Jail, suspended that for 1 year. Conditions: obey all laws, no alcohol or drugs without a prescription, and stay away from an address on Rondell Way. I want you to know that if convicted of the new crime this morning, that would be the petty larceny, you could be found in jeopardy of that, be found in violation of that suspended sentence and have revoked either all or in part and have to serve that time. Do you understand that?
Yes.
They have a couple of warrants as well. Let's go through those first. We're going to be on record in 25 TR 02512. You were arrest warrant issued for failing to complete 64 hours of community service on or before August 18th of this year. Do you wish to admit or deny failing to complete that community service when due?
Admit.
I accept your admission. I will find you in contempt for that one. The next case is exactly the same, 25 TR 03825. And in fact, I had to double check, and I am double checking now. The case numbers, they are different. This one alleges the exact same thing, that you were required to complete 64 hours of community service that were due on or before August 18th of this year. Do you wish to admit or deny failing to complete that community service when due?
Admit.
Accept your admission, find you in contempt of court for that. The new case you have, and I'm going to pull that up right now, is a petty larceny. We're on record in 25 CR 14339. In this case, you were cited for the crime of petty larceny. This alleged to have occurred on September 23rd of this year at Target, 6845 Sierra Center Parkway. Do you understand that charge?
Yes.
How do you wish to plead to that charge, sir?
Guilty.
Do you understand that by pleading guilty, you'll be waiving all of the constitutional trial rights you heard in that video?
Yes.
Do you understand that means there will be no trial in this case and instead we'll proceed directly to sentencing this morning?
Right.
I'll accept your plea of guilty. All right, let's go to sentencing. I'll start with the city. Ms. Ginoli.
Your Honor, on the new trespassing case, it appears that he entered Target where he took approximately $5 worth of energy drinks as well as a Gatorade. Of importance to the city, he indicated to law enforcement that he was withdrawing currently on fentanyl. I glean or suspect, given that the recent suspended sentence, that there's something going on here with Mr. Bach and alcohol and drug issues in particular. I'm not going to ask that you revoke the 45-day suspended sentence. What I am going to ask, though, on the new petty larceny is that consecutive to the 45 days, you impose a 90-day suspended sentence for 1 year with the following conditions: that he obey all laws, that he stay away from Target, that he consume no alcohol or drugs, and that he undergo a substance abuse evaluation and follow whatever recommended treatment, Judge.
All right, thank you. Ms. Burney?
Your Honor, I would be asking for the court, first of all, on the warrants, he was homeless at that time and it was hard for him to comply with the 64 hours of community service. I would ask the court to give him an opportunity to do that. I would also ask the court not to revoke the 45-day suspended sentence on the trespass. However, Your Honor, I would be, if the court is inclined to give a suspended sentence, I would ask for an obey all laws clause rather than an evaluation. I think it might be very difficult for Mr. Bakke to get to a chance to do an evaluation, given the fact that those number one, costs, and two, since he's homeless, it's going to be very hard for him, even if treatment were warranted, for him to get to that treatment. So I would ask for an obey all laws on a suspended sentence.
Thank you. Mr. Bach, anything you want to say before I sentence you and take action on these matters? I'm curious what you have to say, if anything.
No, but I'm in a position where I can get stable housing with my brother, who is a math teacher at Douglas County High. Wife are both in the math department out there.
Wow.
So he's a math teacher, she's a math teacher at the middle school. So they have a house in Douglas County and in the Ruin-Stroth area in Gardnerville.
Yeah.
So I can go out there and live with him, and he's willing to take me.
He's willing to take you, you said?
Yeah.
So we've been managing drug and alcohol issues, drug mostly, for a while, Mr. Bach. And you need help. There's no doubt about that. I don't think you'll disagree with that. The answer is how to manage that, and it didn't work. Community court, it really hasn't worked here. And so how do we get that done? You are entitled to a substance use evaluation for free. You don't have to pay for it. You're on Medicaid. You can go to your provider and ask for an ASAM. They will get you one to determine the level of care, and you'll have to follow through with that recommendation. They'll provide the treatments, and that's all Medicaid. You don't have to pay a dime for that. So how do we get that done?
As soon as I get out of here, I go sign up. And
who do you treat with? Who's your Medicaid provider?
Anthem Blue Cross.
Okay. Do you go to Puff House usually? WellCare?
Yes. Yeah.
Have you stayed at the CARES campus?
I've been there before, but I've never stayed there. But yeah, I've used their services before.
Okay. Ms. Ginoli offers a very interesting resolution to these cases, because I'll tell you what, I was just going to revoke the 45, put you in jail for that amount of time, probably lay some more jail time on top of that. That doesn't really get us too far, but it does close these cases up. So here's what I want to do. When were you taken into custody? Is that on the petty larceny case relatively recently? No. How long have you been in custody?
About 4 days.
4 days? Okay. I want to have you dried out from drugs. You were on a fentanyl runner a while ago, and let's do this. I'm going to follow the recommendation of Ms. Ginoli. I like it. And if you need help managing and or figuring out how to navigate the services, then you can come to the court and ask for the assistance of our case manager, Jenny, who works at Community Court, but Community Court's no longer a thing. And so she's here at the court and she can help you navigate those services, because I want you to follow through. I want you to become clean, especially if you're living with your brother and his wife. They deserve that. No action in 25 CR 06042. You are still on that suspended sentence. On the new case, petty larceny 25 CR 14339, I'm going to run consecutive to that suspended sentence, 90 days in the Washoe County Jail. Suspend that for 1 year. The conditions obey all laws, no alcohol or drugs without a prescription. You will obtain a substance use evaluation through your provider. That's going to be at WellCare. They will do that for you. And we will determine the level of care. And then you have to follow that recommendation, that level of care recommendation. You can complete that substance use treatment down in Douglas County. I don't mind that, but you have to complete it. And if you don't, the warrant will catch up to you and you're just going to be doing the jail time. It's going to be 90 plus 45. Okay. Now let's talk about the community service. You never got that done. I don't think you're ever going to get that done. I think other things got in your way. So 64 in both cases, it'll be 5 days Washoe County Jail. That's the 64 hours converted to jail time. And 25 TR 02512 will run consecutive to 25 TR 03825. That's the 5 days in jail. So you're going to spend a little bit of time in jail. You're going to be clean when you get out, and make sure you follow through with that suspended sentence. Okay.
All right.
Thank you.
Judge, are
Elizabeth-
you issuing a stay away order?
Oh yeah, stay away from Target. Thank you very much. That'll be part of my suspended sentence as well. Thank you. Let me note that in my judge's notes here. Stay away Target. Just 1 second. 225 CR 06042. Good. No action. Alyssa Bailey. Ms. Bailey, good morning.
Morning.
Did you watch the video this morning that contained your constitutional trial rights?
Yes.
Did you understand the rights and the penalties associated with misdemeanors and contempt of court?
Yes.
And did you have sufficient time to speak with your lawyer this morning, Ms. Burney?
Yes.
First matter is 25 CR 12085. In this case, you were charged with disorderly conduct. This was alleged to have occurred on August 16th of this year. You entered a not guilty plea on August 19th, set the matter for trial. That trial was set for September 23rd, but allegedly you failed to appear for that trial date. Do you wish to admit or deny failing to appear?
Admit. Well, I tried to call and get it rescheduled, but nobody would get back to me.
All right. Do you wish to admit not being there?
Yes.
I accept that admission.
Your Honor, I was going to ask the prosecutor if she'd be willing to dismiss that charge for my client's plea to the petty larceny.
Ms. Giannoli?
I'm a bit apprehensive about that simply because of Marcy's law implications. Law enforcement to contact the victim. She knows the defendant. I'm a little worried about doing that, frankly.
Well, is it possible to have the victim or alleged victim on the disorderly conduct make an impact statement as to the petty larceny? We'd be willing to do that.
I'd be willing to do that, as long as there's an agreement between the parties at sentencing that she could address the court if she wished to.
We would agree to that.
All right, thank you. Let me note that agreement stipulation that be in 25 CR 12085 and offer victim impact statement sentencing. All right, let's go forward. Ms. Bailey, do you accept that offer that city will dismiss the disorderly conduct in exchange for your plea to the petty larceny at Target?
Yes.
We're on record then in the new case, the Target case. Let me pull that up. 25 CR 15068. In this case, you were charged with the crime of petty larceny alleged to have occurred on October 9th at 6845 Sierra Center Parkway. Do you understand that charge?
Yes, and then I already signed, sorry to interrupt you. I signed
okay.
paperwork with Target already for a no trespassing with them and understanding what that meant. So
All right. How do you wish to plead to that charge?
Guilty.
Do you understand that by pleading guilty, you'll be waiving your constitutional trial rights?
Yeah.
Do you understand that means there will be no trial in this petty larceny case and we'll proceed to sentencing?
Yes.
We're going to continue sentencing in custody for a victim impact statement, counsel?
Yes, please, Judge.
Yep. Do you understand sentencing will not be had this morning, Ms. Bailey? Instead, we'll continue sentencing. Sentencing will be had Wednesday morning because the victim in the other case, the disorderly conduct case, is entitled to be heard in that matter. And so we'll have to continue sentencing. You'll remain in custody pending sentencing. Do you understand that?
Can I do the no contest then?
Not guilty?
Yeah.
Yep.
Sorry.
Strike everything. Everything's stricken. No agreements, no offers. Let's go back to the other case, 25 CR 12085. In this case, you admitted the warrant for failing to appear for that trial date. You want to maintain your not guilty plea on this disorderly conduct and reset that for trial?
Yes, please.
That'll be the order. Let's reset it for trial and then we'll go to bail.
November 26th in Department 3.
Thank you. November 26th in Department 3. That's the original department who had this case set for trial, so it will remain with that department pursuant to Rule 2 of the Reno Municipal Court. Now, we're going to go to our new matter, 25 CR 15068. You want to enter a plea of not guilty to the petty larceny alleged to have occurred on October 9th of this year at Target, yes?
Yeah, and then just if I could
That'll-
get served.
You wait. I need to know what you want to do.
I
A
just
not
wanna-
guilty
whatever's
plea
easiest
is
to
a
get
not
out,
guilty.
get my
A
drink.
not, say again, hang on. A not guilty plea means you want to set it for trial. A no contest or a guilty plea means that you're waiving your trial rights. There will be no trial and you will be sentenced on the case. Do you understand that?
Yeah.
What I was talking about relative to your guilty plea or your no contest plea is that we would not go to sentencing this morning because the victim in the other case, the disorderly conduct case, who will be heard on the petty larceny case pursuant to the stipulation, the agreement between the attorneys, we will continue sentencing till Wednesday to allow that person to be here if they wish to be here.
So no matter what, you're not walking out those doors today, regardless of what plea you enter.
You will be placed on a no bail hold pending that sentencing hearing, and then you'll be sentenced on Wednesday. That's what I was trying to convey to you. And it doesn't matter whether it's a no contest or a guilty plea. Otherwise, you can enter a not guilty plea to that petty larceny and set it for trial. And you can, frankly,
Yeah, I'll do not guilty.
You can have it on the same trial date as your disorderly conduct and in front of that same judge.
Yeah, not guilty.
Not guilty plea is entered. I'm going to appoint counsel.
Yes, appoint counsel, because this girl doesn't know what she's doing and she has selected all three plea options. Yeah, definitely counsel.
Let's get a bench trial date.
It was November 26th at
Oh.
8 a.m., Judge.
Thank you. I apologize. It is the same trial date, November 26, 8 o'clock in the morning. Let's go to custody status. Ms. Ginoli.
Your Honor, with regard to the petty larceny, as indicated, it's alleged that she entered Target. She took a fair amount of items, totaling $1,192. Court services indicate she's got a history of nuisance offenses and failures to follow court orders. She was last in jail on September 11th, 2025. I do have ongoing concerns given the disorderly conduct and the fact she failed to appear for out-of-custody arraignments. Court services also noted another pending matter, which she has. It's a simple battery and obstructing and resisting set in D1 for a trial on 10/21. Those are merely allegations. I understand that. I did look in that case in Odyssey. She also has a pretrial violation in that case too to be addressed. Again, merely allegations, but this just goes to show that Miss Bailey is there's something going on here, and I have concerns for community safety. I have concerns for her ability to appear for court. And so I believe bail is appropriate in this case. On the petty larceny, I'm going to ask for 1,000. Actually, bail's been set, I believe. Was bail, did she have a hearing on 10/11,
I'm
Judge?
so sorry. She may have had a hearing on Saturday.
I think she did, and I think it was set at $2,000.
It was, counsel.
So I retract all those things.
Sorry, my bad. I should have realized that. Bail has already been set at 2,000. That bail will stand. We will, however, set a bail in the disorderly conduct given.
Strike everything again. Oh my gosh. What are the chances we get a gal who's gone through all 3 pleas and they've had to strike her all testimony, or well, not testimony. They've had to retract everything twice now.
And her failure to appear for that case.
Thank you, Judge. In light of the circumstances I just mentioned, I'm going to ask for $1,000 bondable in that case. Should she be released, conditions that she obey all laws, consume no alcohol or drugs, and stay away from the victim property, please.
All right, thank you. Ms. Bernie?
Your Honor, I would defer to the court at this time because bail has already been set.
All right, thank you. All right, bail's already been set in the petty larceny case, $2,000 bondable. That bail will stand. We'll see her on her trial date. Bail has not been set in 25 CR 12085. Her OR was revoked because of her failure to appear. Bail will be in the amount of $1,000. It'll be a bondable bail set that'll run consecutive to the other case. She'll have to post 2,000 and 1,000. The conditions are that you will obey all laws, no alcohol or drugs without a prescription, and you will stay away from the location in this case. Let me find it. You'll stay away from the 1900 Idlewild Drive. That'll be the order. We'll see you on your trial dates. Thank you.
Thank you.
Jamie Blackledge.
Morning, Judge.
Morning, Mr. Blackledge. Sir, did you watch the video that contained your rights this morning?
Yes, I did.
You understand the rights and the penalties associated with misdemeanors and contempt of court?
I do, sir.
And did you have sufficient time to speak with your lawyer this morning?
Yes, sir.
We have 3 matters with you, 24 CR 15284. In this case, you entered a plea of no contest to a drug paraphernalia case. The case was continued to have you appear at community court. Allegedly, you failed to do that. That failure to appear allegedly occurred on June 25th. Do you wish to admit or deny failing to appear?
I would like to say I was under the impression that I got time served and I was only supposed to report to Marianne. I did show up. She was not there that on that Wednesday, and then the following Wednesday there was a holiday, so you guys weren't having court. So I showed up that following Wednesday.
Okay.
Marianne.
That's fine. I'll quash that warrant. We'll go to sentencing on that case. Let's go to the other case, 25 CR 10806. In this one, you were charged with use or possession of drug paraphernalia alleged to have occurred on July 28th of this year. Do you understand that charge?
Yes, sir. But those last 2 were supposed to be with the Marianne thing, and I was supposed to have time served.
This is different. This is different. This is another case. This is another case that happened on July 28th. You said you were supposed to be at community court with Marianne on 6/25, a month earlier. And this one was over at State and River.
And Judge, just to clarify, the 806 is a brand new case that he never appeared anywhere for.
Exactly. You failed to appear anywhere for this case.
I don't remember that at all, Judge.
All right. So you don't remember the use or possession of drug paraphernalia over at State Street and the River Path?
No, I don't. It's just this one that happened a couple days ago.
No, July 28th, 12:04 in the afternoon. I mean, it's just the usual case. I can't give you much more information than that.
How can you expect him to remember? He was high.
I don't know. I remember having 2 that they said I had time served, and then I went down and
You haven't handled this case at all. This is a fresh case that needs to be addressed this morning. And then you have another drug paraphernalia case that we need to address as well.
which
You're
was
required to appear at community court on July 30th on this particular case, but allegedly you failed to appear. So do you want to admit or deny failing to appear for this case?
didn't show up to it, so I didn't
All
know.
right. I'll accept that as an admission, find you in contempt. Before I get to that case, let's talk about the other case that we have, the more recent case, which was on October 9th.
Yes, sir.
On this one, you were arrested for this one, so I imagine you probably have some memory of it.
Yes, yes.
And I'm not trying to be facetious. I'm actually asking if you have a memory of it. So this is on 25 CR 15069. You were charged with use and possession of drug paraphernalia alleged to have occurred on October 9th. This one in the area of Wells Avenue at Truckee River. Do you understand that charge?
Yes, sir.
Great. How do you wish to plead to that charge?
No contest.
You understand you'll be waiving your constitutional trial rights by entering that no contest plea?
Yes, sir.
I'll accept your plea of no contest. Ms. Ginoli, do you want me to canvass on the one that he doesn't remember? He's already entered a plea of no contest to the other one in 24 CR.
No, Judge, I'll make a motion to dismiss that.
That'll be the order. Thank you. That charge is dismissed. I'll just quash that warrant in that case. Let's go to sentencing. Ms. Ginoli, please.
Thank you, and I have concerns of him having pretty severe issues, of drug-related issues, given that he's got 3 paraphernalia charges. Ms. Burning, I presume that he is a vet, given that he's talking about Mary Ann. Is that correct?
Yes, that is correct.
All right. Judge, what I'm going to ask, I think for community safety and for his own good, he needs some drug treatment. So what I'm going to be asking for here, given the number of paraphernalia charges, is for a 45-day suspended sentence for 1 year, conditions that he obey all laws, consume no alcohol or drugs. I'm going to ask that he works with the VA in order to obtain a substance abuse evaluation and follow whatever recommended treatment.
Thank you. Ms. Burning?
Your Honor, I explored the possibility of treatment with Mr. Blackledge. That is not anything that he is interested in doing at this present time. He has a place to live at Nevada Inn Towers, so he's no longer without a fixed address. I would be asking for the court to suspend a sentence that has him obey all laws.
Mr. Blackledge, what do you want to say, if anything?
I have been working with the VA. I went in there last week for more permanent housing under my name. I just did my intakes, and I just have to go in and get my my driver's license or ID, and I was supposed to go there tomorrow on Tuesday through the ambassadors.
You need drug treatment.
I would
So if you're going to refuse drug treatment, then I'm just going to sentence you to jail time. I mean, that's kind of I've got 2 things I can do, right? I can sentence you to treatment, which would put you in a better position to have sustainable housing. Because once you get that housing, it's just going to fall apart on you because the drugs will get in the way. This is the cycle you've lived, right, for your life. Or I can just sentence you to jail time because you're refusing to follow through with drug treatment. And even if I order it, you're not going to do it, right? I mean, that's pretty much what you're saying.
Oh, if you order it, I'll do it.
Will you?
Yes, sir.
If you don't follow through, then I'm going to put you in jail. And I think that's lousy. I mean, that's a stupid thing to do on cases like these. Way better to treat. And I know you're resistant. You're saying, Judge, I'm not ready to do that, but you got to do it because we don't have an alternative. So 45 days, Washoe County Jail, suspended 1 year. Obey all laws, no alcohol or drugs without a prescription. You are ordered to get a substance use evaluation at the VA. You know they can do that there. And you are ordered to follow through with that treatment plan. That's at NADCP, or excuse me. Shoot, Ms. Burning, what is it called? They have a program at the
No,
VA.
you're right. You're right, Your Honor. You said it. It's the NADCP that they report to,
Yeah.
so that they don't have to go through a veterans outreach coordinator.
That's exactly right.
They report directly.
Great. So that's what you're going to do. You've got to follow through and do the programming there. They have all the programming there. That's the beauty of being a veteran. You have access to all of it, but you're ordered to do it. You're ordered to comply with it and complete it.
Where do I go for that?
You just go to the VA and get your substance abuse evaluation and say, I need this evaluation and I need treatment here at the hospital, here at the VA for it. And they will schedule you for their probably outpatient treatment, my guess is. And then you'll have to follow through with it.
I can do that.
Good. I'm glad we're on the same page. Time served in the drug paraphernalia in 24 CR 15284. Time served on the warrant in that case. All cases are closed except for the new one, which has that 45 days. What I'd like you to do is when you're released from custody, report on release to the Reno Municipal Court to sign up for supervision. given that you're homeless and you don't have places right now, you don't have employment, I'm gonna waive, I'm noting this, waive supervision fees. So you're not out of money. I don't want you to be out of cash here. That's not what I'm trying to do. I'm trying to get you treatment. And then you're ordered to go to the VA to get treatment, okay?
So I just go to the courthouse and then
Go to the
VA?
courthouse first and they'll tell you where to go from there.
Okay.
Thank you, sir.
Thank you.
Corey Kavanaugh.
Morning, Your Honor.
Good morning, Mr. Kavanaugh. You have
How much do you want to bet that he was already spinning ideas in his head of how to get out of it? And the judge dropped the charges basically on those other, what he was facing. So it's all suspended for a year. He's got to, be good for a year, but I don't know that he is ready. I really don't. I wish the best for him. He deserves a sober life, but I don't think that he's ready for it yet.
3 matters with us. Right. Did you watch the video that contains your rights?
Yes, sir.
You understand the rights and the penalties associated with misdemeanors?
Yes, sir.
And did you have sufficient time to speak with your lawyer, Ms. Burning?
Yes.
Let's go on record on your older case, 21 TR 18227. You were charged with making an improper U-turn and driving on a suspended license. These charges were alleged to have occurred on December 17th of 2021. You entered not guilty pleas to those charges. Those not guilty pleas entered on January 20th of 2022. The matter was set for trial. Allegedly, you failed to appear for that trial date on April 19th of 2022. Do you wish to admit or deny failing to appear on that date?
Admit.
I accept your admission. I will find you in contempt. Do you want to handle this matter this morning, or do you want to maintain those not guilty pleas?
No, I want to do no contest because I forgot about it. And
All right. How do you wish to plead to the driving on a suspended license?
no contest.
How do you wish to plead to making an improper U-turn?
No contest.
You understand that by pleading no contest to these or any other charges this morning, you'll be waiving your constitutional trial rights you heard in that video?
Yes, sir.
I'll accept your plea of no contest on both charges, find you guilty. All right, next case is 25 CR 08535. You were charged with trespassing alleged to have occurred on June 10th of this year in the area of 2800 Enterprise Road, the Highlands. Do you understand that charge?
Yes, sir.
Allegedly, you failed to appear to court to answer to that charge. That failure to appear alleged to have occurred on July 15th. Do you wish to admit or deny failing to appear?
Admit. I did come to court, but they didn't let me in with my backpack, so I didn't come back. So yeah.
All right.
My fault.
All right. I'll
Yeah.
quash that warrant.
Yeah.
How do you wish to plead to the trespassing?
No contest.
I'll
Yeah.
accept your no contest plea and find you guilty of that one. Ms. Ginoli, do you want me to canvass on the newest sitting line camping on August?
No, Judge, I'll dismiss that.
That one will be dismissed.
Thank you.
Let's go to sentencing.
So Judge, on the 2021 case, that was an accident case. I looked into the accident report and the vehicle that he was driving was not his own, but it did have insurance. I'm hopeful that restitution has been worked out. I'm going to defer to Your Honor here with regard to the appropriate sentence there. As indicated on the trespassing, he was at 2800 Enterprise Road. He refused to leave. I don't have a lot more information there, so I'm likewise going to submit that matter to Judge.
All right, thank you. Ms. Bernie?
Your Honor, on the trespass, my client was actually helping another person get rid of their property off of that Highlands property. But he willingly admits that he was there at the time. He's done 4 days in Washoe County Jail, and I would be asking for the court to give him credit for time served.
All right, thank you. Mr. Kavanaugh, anything you want to say before I sentence you?
Yeah, that I was technically on the property, but I was just helping some friends like get their stuff off the property because they were camping. So I was just happened to be there helping them, and then I got trespassed.
All right, great. In the 21 case, time served on the U-turn. Do you have a driver's license yet?
No. Yeah, I imagine that's the thing that's been preventing me from getting it.
No, it was suspended before that.
Oh, really?
Yeah. You failing to appear did cause your license to get suspended. There's no doubt about that, but you were originally cited for driving on a suspended license. I don't know why it was suspended.
Oh yeah, I can't remember either. I haven't had a license in a while, but
All right. Don't drive a motor vehicle if you're not allowed to drive. That's an order from this court.
Sounds good.
Time served on the driving on suspended license, time served on the warrant. I'm gonna actually time serve you on the trespassing in this case, given the circumstances. I've already quashed that warrant and the other charges dismissed. Good luck to you, sir.
Thank you, Your Honor.
Thank you. Christian Key.
Morning, sir.
Good morning, Mr. Key. All right, we have two matters with you. First, I'm gonna alert you to a suspended sentence that was issued. I issued that on April 24th of this year. I ordered 15 days in the Washoe County Jail, but suspended that for 1 year. Conditions: obey all laws, no alcohol or drugs, and stay away from the Bonanza Casino. I want you to know that if convicted of any new charges, you could be found in violation of that suspended sentence and have to serve that time. Do you understand that?
I remember you. Right on. Thank you for your
I'm
help.
glad you have a
That
good
was
memory. Good.
Right on. Yes, sir.
So, great. Did you watch the video this morning that contained your rights?
I listened to it
Great. Did you understand your rights?
here and there. Yes, sir.
Do you have any questions about the trial rights contained in that video?
No, sir.
All right. Did you have enough time to speak with your lawyer this morning, Ms. Burning?
It seemed a little rushed, but she told me if I plead no contest like I wanted to do, I may be revoked on the 15 days that you said. More or less.
Could be. Do you, if you need more time while we're going through this, you let me know, okay?
Okay, yes,
We're
sir.
going to be on record your new case, 25 CR 15078. You were charged with resisting a public officer and use or possession of drug paraphernalia. These charges alleged to have occurred on October 9th in the area of 1131 Steamboat Parkway. Do you understand those charges?
I believe so, yes.
How do you
Yes.
wish to plead to the obstructing and resisting?
I'll just go no contest for both of them, sir.
How about, let's start with the obstructing and resisting. Do you understand that if you plead no contest to that charge, you'll be waiving your trial rights?
Yes, sir.
You understand that means there will be no trial in this case and we'll proceed directly to sentencing?
Yes, sir, but
All
there's
right,
really no way for me to fight that case.
Do you want to fight it? Do you want to enter a not guilty plea and set it for trial?
I don't know how I would fight that.
Well, I don't either, and I can't tell you how to do that, but
Yeah,
you're
he said that his
entitled.
body cam was on, but his body cam wasn't on, so it'd just be hearsay then. There'd be no
You're-
way for me to fight that.
Listen, it's up to you. You're entitled to enter a not guilty plea and have the prosecutor prove this case beyond a reasonable doubt. You heard that right.
Yeah, but then I would be stuck in here without any way to pay
Probably.
my bill. Yeah. So we'll just go with the no contest, sir. That's how I
I
always.
accept your no contest plea, find you guilty. Do you want me to canvass on the paraphernalia, Ms. Janelli?
No, Judge, I'll make a motion to dismiss that.
That'll be the order. The paraphernalia will be dismissed for in exchange for your plea to the obstructing. Ms. Janelli, sentencing.
That sounds cool.
Your Honor, here defendant was in Starbucks yelling at customers who were in the line. When law enforcement made contact with him, it's pretty apparent that he was under the influence and he physically resisted arrest. A pipe was found on his person. By way of background, Judge, we recently had him in community court for an intoxicated pedestrian as well as an obstructing resisting. He opted out. It's pretty apparent to me, though, given that prior case as well as this case, that he's got some drug and alcohol issues that need to be addressed. And if they're not addressed, we're going to continue to see him in custody. I also have concerns in light of the fact that we have a 15-day suspended sentence. I'm going to ask that you not revoke that 15-day suspended sentence. I am going to ask on this new case you impose another suspended sentence, run it consecutive to the 15-day. I'm going to ask for a 45-day suspended sentence for 1 year, conditions that he obey all laws, consume no alcohol or drugs, and that he undergo a substance abuse evaluation and follow recommended treatment, please.
All right, Ms. Burning.
Your Honor, I would be asking that my client has been pretty responsible. And I would be asking for the court to give him credit for time served. I don't think there's need for a suspended sentence in this matter. And otherwise I would defer to the court.
All right, thank you. Mr. Key, anything you want to say?
Three points of interest. On the young lady with the nice white sweater. It says that I was in the Starbucks, never went in the Starbucks. Never talked to anyone in line. That'd be impossible. And also I didn't have a pipe. They were looking for a baseball bat. So a lot of information that was just, none of it really matters, but I'm just saying I was never in the Starbucks.
All right. Well, I think the pipe was the drug paraphernalia pipe they were talking about.
Oh, I thought they were talking about my Louisville Slugger.
No. So
Yeah, 'cause
listen, how long are you gonna go down the road of using and not treating?
well, I was actually clean off of anything for about 3 weeks.
Huh?
I just started having a couple beers because I separated my AC.
Okay.
I've gone to 2 hospitals, had the x-rays done within the like the 7th and the 8th. So the resisting kind of came to like, yo, I have an AC separation, please don't twist
right.
it. And he
All
still
right.
twisted it, and I kind
All
of
right.
like jumped.
So you were self-medicating and then you lost your shit.
All right. All right.
But
And you've not gone back to the Bonanza, right?
oh God, no. That's not for like what, another year and a half?
I'm good. The suspended sentence stays open in that case with the ongoing condition of stay away from the Bonanza.
Of course, yeah.
In the new case, I'm going to impose 30 days consecutive Washoe County Jail, suspended 1 year, obey all laws.
Okay.
No alcohol or drugs without a prescription. I'm not going to have you do a substance use evaluation at this point. If you continue picking up these charges, I'm going to either order you to do that or you're going to do a significant amount of time in jail. That's kind of what that's what the balance is, okay?
Yes, sir.
All right, thank you.
Thank you, dude.
Oh, the other order in this case, Mr. Key. In the new case, you are ordered to stay away from that Starbucks at 1131 Steamboat Parkway. If you violate that order, I'm going to put you in jail for that time. You understand?
Sounds good.
All right, thank you. John Ketchum.
Hello, Your
Mr.
Honor.
Ketchum, good morning.
Good morning, sir.
Good morning. This case finally wound its way around back to you, huh?
Yep.
24 CR 02540. You entered a plea of no contest to a simple battery case. We actually had the case postured for a referral to, I believe, COD court, if I'm not mistaken. It's been a minute.
Yes, it has been. And if I can, I don't know if it's my turn to speak or not, but
I'm going to hear from you in just 1 second.
Sure.
Apparently, the allegation, let me pull it up, is that you failed to appear. Just 1 second. Let me read my judge's notes on this.
Of course.
I had you going to COD court, I recall. For Michigan, I remember that. 2,500 bond or cash only bail. PTNTO extended and notice email info continued to today's date. Maybe I might be confusing it with another case. You failed to appear on this case for sentencing on July 2nd of last year.
That is correct.
Entered a no contest plea to the simple battery in 24 CR 02540. Do you wish to admit or deny failing to appear for that sentencing hearing, sir?
I do admit to not showing up, but I did contact the court that day to try to my public
Defender?
attorney. Yeah, my public defender, pardon me, sir. Was switched on me in the last moment, like the day
Yeah.
before, and I wasn't notified at all. And so I was trying to get a hold of the public defender, and then I found out the morning I was supposed to be coming in to go to court, that my public defender switched on me. I didn't have a chance to even have any kind of conversation with him. So I tried to call the court to see if I could change the court date. They couldn't change the court date, and then I was out of state as well, which I think I
Yeah, you were in Michigan.
Yes, and then so the getting back here was not easy for me whatsoever. And
Yeah.
then on top of that, I came back because my father needed me because of medical needs, the same father that I
Yeah.
had an incident with. And so I've been taking care of him ever since. I still take care of him. And
All right. And I want you to know that before I issued that bail, I actually stayed that warrant
yeah.
until July 11th so that defense counsel could contact you and then contact the court so that I wouldn't have to have that issued because of because of the nature of you being out of town. Nonetheless, we're here where we are, okay?
Yes.
So let's I've accepted your admission. I have found you in contempt for failing to appear. How do we move forward to sentencing?
Judge, I have a request.
Please.
It's given the DFTA for this case. I can note that the victim, excuse me, has been very actively involved. In fact, he contacted our advocate on July 2nd, merely after the defendant FTA'd, asked for a status, and specifically asked that he be notified when his son was picked up on the warrant because he wanted to make a determination whether he wanted to be present for sentencing and what request he wanted to make. So given that, Judge, per Marcy's law, I believe we have an obligation to continue this. I'm going to ask that we continue this until Wednesday. Given the FTA, I don't believe that an out of custody info is appropriate. I'm going to ask we continue this until Wednesday so we can reach out to the victim to see if he wishes to make a statement, please.
That sounds interesting. That sounds right. Ms. Bernie?
Your Honor, I would be asking for the sentencing to be imposed out of custody and that we could set a time for that. My client needs to be able to be a caregiver, and for those reasons, he needs to be released if the
All
court
right.
would do that.
Caregiver to his father, the victim of
Yes.
the case.
Yeah,
Right.
and
And
he needs me badly, Your Honor, badly. He's wheelchair bound. I have to bathe him. I have to he can't go to the bathroom without me. I have to change his bedding every day. I have to
Here's
feed
what-
him every day.
I hear for you. When
I think we need to call Adult Protective Services at this point. If he's been incarcerated for several days, and if his father is that bad off, he's been getting by with absolutely no care and no help since this guy's been picked up. Somebody needs to check on that dad.
were you arrested on this?
About a year and a half ago.
No, when were you brought into custody?
Oh, I'm the 10th. I'm the 10th, sir. And my father's very concerned. He had talked to him last night. Okay, yeah, sorry.
Here's what I want to do, Mr. Ketchum. I'm going to continue it one day because I want to make a decision whether whether your dad wants to be part of sentencing or not. And then I'm going to either sentence you tomorrow or release you tomorrow for a sentencing hearing. So that's what I'm going to do. I'm going to give us one day to do this. It sounds like your dad is at a place where, can he pick up the phone? Can he answer the phone?
No, you're not. I'm telling. Like, it took me. I had to call 8 times just to get him to answer once.
Oh.
That's the way he is. He's not well, Your Honor. Not even kind of well. And he's very he needs me home badly. Like
I can't just take your representations as truth, much as I believe you. I can't just take them at truth and assume that everything's good, and then I release you back out of custody to care for him, and then something tragic happens. And I just can't do that.
Well, he said he was going to try to call the jail. He said he was going to try to call the court before today so that you could at least hear from him for him to testify to the fact.
I'm going to continue it one day to see what your dad wants, and the city
wants me out here as soon as possible. I know that.
The city will make all attempts to contact him so that we can see what his wishes are in this case, so that we can proceed with his wishes in mind. Case is continued one day, and I'll see you tomorrow morning.
Okay. Thank you, Your Honor.
No bail. All right, thank you. I'm going to put that matter aside. Adam Marquez Barajas.
Morning, Your Honor.
Good morning. Sir, your true and correct name, Adam Marquez or Adam Marquez Barajas?
You could just call me Adam Marquez. Barajas is like my maiden name.
All right, I understand that. Did you watch the video that contained your rights this morning?
Yes, sir.
You understand the rights and the penalties associated with misdemeanors?
Yes, sir.
And did you have enough time to speak with your lawyer?
Yes, sir.
All right. We're going to go on record first in your warrant case. Let me pull that up. In this case, a warrant issued for failing to appear. There it is. The warrant indicates that on December 19th of 2024, Judge O'Neill ordered you to provide proof of insurance and driver's license or pay $938 in fines or fees on and before June 16th of 2025. Do you wish to admit or deny failing to provide proof or pay the fines?
I admit, but that's also because my dad's car. I went to the DMV for the last 3 months, and he has a lot of lights on his car. So every time I went to the DMV, they always said that the lights aren't able to at least do the driving test.
Sure.
I would have had my driver license at least 3 months ago. So basically, I would have had it by now. But the thing is, just like I said, my dad's car is not very good, dude. That's the only way I could say it.
I accept your admission. How come you didn't show up to court before June 16th and say exactly that?
I am responsible and I have nobody to blame but myself. And
All right, I accept that.
I apologize.
I accept that.
I hear you. I should have went to court that day. I very much will apologize, and I got nobody to blame but myself that day. It's just that I was, very frustrated, very nervous because I also still, like I said, was still working on the insurance, working on my registration. I also had to go to my job. I have a job today. I have Sprouts, and I would love to keep that job. He's a very nice manager, and I'd love to keep that job in that position.
Great.
The thing is, I promised the end of this month, I will have a driver license, I will have a license and registration.
Great, that's good, and we're beyond that. So good, and you're gonna have to set up payments on that case. So you don't have to, you're not gonna get the benefit of having charges dismissed or reduced fines. We can't undo, we can't unwind and back things out. So
Understandable, sir.
be on a payment plan, great. Let's go to our new case, which is 25 CR 15079. You were charged with the crime of domestic battery, a first offense. This alleged to have occurred on October 9th of this year in the area of 960 Wilkinson Avenue. Do you understand that charge?
Yes, sir.
How do you wish to plead?
That one, not guilty.
I accept your not guilty plea. Let's see here. A case has already been reviewed for probable cause, but not for appointed counsel. Let me see if you qualify. You do qualify for the appointment of counsel. I will appoint an attorney to represent you. Let's get a pretrial conference date.
November 20th at 8 a.m.
November 20th, 8 o'clock in the morning is your pretrial conference date where you will be at court, your attorney will be at court, and the city attorney will be at court to see if we can resolve this matter. Like I said, you will have an attorney representing you in this case. I understand that bail's already been set at Saturday bail hearing in that matter. On the warrant case, your time served on the warrant, you were ordered to report upon your release to the Reno Municipal Court to sign up for payments of that $938. That's the total fine owed, okay?
Yes, sir.
Thank you.
One more question, sir.
Yes, please.
They said 938, but if I get insurance, it'd go
No,
down to
like I said, we're beyond that. Had you
Okay.
done that before that June 16th date, absolutely you'd be entitled to that. We're beyond that, so it's already set in stone. You're going to pay that full fine.
Okay. Is there anything else you need to tell me or no, sir?
No, thank you.
All right. Thank you so much, sir.
Thank you. Eduardo Martinez.
Morning, Your Honor.
Mr. Martinez, good morning. Sir, did you watch the video containing your rights this morning?
Yes, I did.
Did you understand the rights and the penalties associated with misdemeanors and contempt of court?
Yes,
And did you have sufficient time to speak with your lawyer this morning?
yes,
We have three matters with you. 24 TR 01703. You were charged with driving without a valid driver's license and without valid registration. These charges alleged to have occurred on February 10th of last year, 2024, in the area of Sutro at East 8th Street. Do you understand those charges?
yes,
Allegedly, you failed to appear at court to answer those charges. That failure to appear alleged to have occurred on March 12th of last year. Do you wish to admit or deny failing to appear on March 12th?
I admit.
Accept your admission, find you in contempt. How do you wish to plead to the registration? Or excuse me, the driver's license?
Well, the judge told me that all those charges was gonna drop by doing
This is a new case that you
community-
didn't show up for court on, sir.
oh,
So how could a judge talk to you on a case that you didn't show up to court on? I don't understand.
no, I did show up to court.
Well,
But
you just
I showed
admitted
up,
that you failed to appear.
Yeah,
Sir,
so-
sir. I just let you know what the charges are, and I told you that you failed to appear on this case on March 12th. That's the allegation. And you said you admit failing to appear. Do you,
Yeah,
do you
I'm
say
not-
now that you actually did show up to court?
No, I thought it was for the 11 of.
Oh, we have
September.
other charges. Yeah, we have similar cases.
Okay.
This is just one of them, okay?
Okay.
How do you wish to plead to driving without a valid driver's license alleged to have occurred on February 10th of 2024?
Guilty.
You understand that by pleading guilty to this or any other charge this morning, you'll be waiving the trial rights you heard on that video?
Yes,
I'll accept your guilty plea. Do you want me to canvass on the registration, Ms. Janoli?
No, Judge, I'll make a motion to dismiss.
That'll be the order. Registration's dismissed. Let's take you to your other case. And then we have that warrant that you were talking about as well. 24 TR 01706. In this case, you were charged with operating a motor vehicle without proof of insurance. This was alleged to have occurred on that same date of February 10th of last year. And this one was in the area of Sutro at East 4th Street. Do you understand that charge?
yes,
Allegedly, you failed to appear at court on that same date. I'm going to quash that warrant because we already have another warrant on that case. How do you wish to plead to the insurance violation?
guilty.
I accept your plea of guilty. And then finally, let's talk about the warrant case 18, this is a while ago, 18 TR 12473. Apparently you were required to pay fines or fees in the amount of $554 that were due on or before April 24th of this year. Let me check that out. Give me a minute here. This was Judge Tammy Riggs that had this case originally. And then a warrant issued. So somewhere in the middle here, someone had you, I don't know how they, let me look at the warrant. So Judge O'Neill signed an order indicating that you were required to pay fines or fees in the amount of $554 on or before April 24th of this year. I'm going to go ahead and quash the warrant. We'll use all jail time to satisfy those fines, okay? All right, let's go to sentencing. Ms. Giannoli, does the city have a position on the driver's license?
No, I'll submit, Judge.
Thank you. Ms. Burney?
I'd submit, Your Honor.
Thank you. Mr. Martinez, anything you want to say before I sentence you on any of this?
No.
Okay, so on the warrant case, 18 TR 12473, it'll be 3 days Washoe County Jail, time served, and that goes exclusively toward that fine. So that fine is all paid off by your jail time, okay? So you don't owe that $554 because I've quashed that warrant, it's done, and your jail time goes to that.
Thank you.
24 TR 01703, that's the driver's license charge. Time served on the driver's license. Time served on the warrant. And on the insurance in 24 TR 01707. And that's back in 2024, 5 days Washoe County Jail, credit time served. I'll run it concurrent. That's it, all closed up. Thank you, sir.
Thank you.
Thank you, sir. Appreciate that. All right. So Israel Shavira Ortega, please stand, say here.
Yeah.
Excellent. Thank you. And you can stay standing. Gregorio Rodriguez Tafoya.
Aye, sir.
Cedric Espinoza.
Yes, indeed. Yes, sir.
Craig Williams. Gentlemen, would you all please raise your right hand? Do you and each of you in the back there, raise your hand.
He's handcuffed, Judge.
Do what?
Handcuffed, Judge.
Oh, okay. Well, thank you. Do you and each of you solemnly swear or affirm the testimony that you will give in your matter now before the court will be the truth, the whole truth, and nothing but the truth, so help you God? If so, please say, I do.
I do. I do. Yes.
Thank you, gentlemen. You can put your hands down, remain standing. First of all, you're all here for a guilty plea, and because these are misdemeanors, yes?
Real quick, 3 of my clients are Spanish speakers, and we do have Richard here to translate for them.
Sorry.
It's okay.
Okay, let's start over. Richard, good morning.
Good morning.
I guess we're not doing a simultaneous with headphones, so you'll need to I'll need to pause for you to repeat what I'm saying. Is that right?
No, I think, well, I wasn't prepared for that. We usually turn on the interpretation feature on this one for simultaneous interpretation.
I don't know how to do that.
Nasida knows.
Nasida, is that on? It says language interpretation available. Click here to get started, but then it went away. Oh, what's going on? Nasida, have you started the simultaneous interpretation feature? Nasida, we're not getting a response from you. I don't know if you're talking.
I clicked on it, Judge. It should be good.
Okay. Are they just going to read words on a screen, or how does this work? How are they able to hear in Spanish what I'm saying in English?
Richard usually puts it out there for them.
But are they hearing it or are they reading it?
They're hearing it.
They're hearing it?
Sir.
Okay, but I don't see headphones on them. So how are they going to hear him talking while I'm talking?
Going back and forth this audio.
So I'm going to speak and then he's going to speak. Is that correct?
Yes, sir.
Okay, that's why I was in the beginning saying I think I'm going to need to pause. I'll talk and then I'll let Richard translate it. And who are the persons that need the Spanish interpretation?
You, right? You,
So Luis Ibarra,
Okay.
and then the Ortega,
Basically, all three of mine.
Okay, okay,
Then
so it's a
Perez
mixture.
Gonzalez.
Okay, all right. Let me go ahead and ask, Richard, if you'll raise your right hand, please. Do you solemnly swear or affirm that you will make a true interpretation of the questions asked of the witnesses by the court or by counsel and repeat their answers back in the English language in your best skill and judgment, so help you God? Richard, I didn't hear a response. I think you're saying I do. If I could read lips confidently, I would say yes, but I think everything you're saying is going into the interpretation. I'm not able to hear you, so I'm not going to be able to hear their responses that you're repeating back.
Okay, Judge, so
Now I can hear you.
the interpretation feature has been turned off. Okay, so what I was trying to explain is to use the interpretation feature, you have to do them in two groups. One group is in English, and then when you finish the English, then you can do the Spanish group so that you can do the interpretation. Or you can start with the Spanish group first, and then after you finish the Spanish group, then you can do the English group.
Okay, let's
That's
start with the Spanish group first.
the Spanish group first. So when you turn on the interpretation feature, it's off right now, but when you turn it off, when it's turned on, when Nasira turns it on, you'll have to select English on your computer so that you can hear me speaking. The jail will select Spanish and they'll hear me speaking to them in Spanish. So you'll have to select English. The DA will have to select English. The jail will have to select Spanish. The attorney will have to select English. Everyone will
Okay.
have to select the language.
This is the first time I've ever done this. Thank you for teaching me. So I guess, Nasita, we're going to do the Spanish first. And okay, it looks like I'm just waiting for the chance to select English.
The attorney on the bottom, Mr. Dwight McDonald, he has been really enjoying the show as well. He's been laughing through this. He finds it just as entertaining as we do.
Nasita, it's not giving me an option to select English.
It's normally on the bottom, and then
Yes, sir.
click on more. It's on there about interpretation.
Okay, let me try more interpretation. English.
Yes.
Yay, thank you. Hey, now I hear Richard. Okay, so this is going to be Luis Marmolejo Ibarra, and what are the other names, please? Okay. Okay. Okay, I've got those three pulled up here. So, okay, so in the jail, everybody be seated for a second, and only the following gentlemen please stand. Gentlemen in the jail, please be seated. Would somebody please ask the gentleman in the jail to take a seat? Okay, now if you hear your name called, please stand. Luis Marmolejo Ibarra, Christopher Perez Gonzalez, Israel Shavira Ortega. As best you can, each please raise your right hand. Do you and each of you solemnly swear or affirm the testimony that you will give in this matter now before the court will be the truth, the whole truth, and nothing but the truth, so help you God? If so, please say, I do. Thank you, gentlemen. You can put your hand down. I have some paperwork from each of you here that has your signature and your fingerprint on it. This indicates to me that you have read and understood what you signed. I have several questions. First of all, is this your true and correct signature or fingerprint? Did you sign the paperwork freely and voluntarily? And did you read and understand what it was you signed or provided your fingerprint for? If so, please say yes. Did you understand that by entering into a plea bargain, you waived the right to a trial by a jury of your peers or to a hearing before the court on a revocation of community supervision? Are you making that waiver? You also waive the right to remain silent, and you waive the right to make an appeal. Do you understand that? Israel Shavira Ortega, are you pleading guilty to driving while intoxicated, second offense, a Class A misdemeanor committed August 24th, 2025 in Lubbock County, Texas? And are you pleading guilty because you are guilty and for no other reason?
Sí.
Christopher Perez Gonzalez and Luis Marmolejo Ibarra, are you waiving the reading of the allegations in the motion to revoke community supervision and pleading true to those allegations because they are true and for no other reason?
Sí. Sí.
Counsel, do you find that all three of your clients are competent to make their plea of guilty and pleas of true?
Yes, Your Honor.
Gentlemen, I will find that all of your pleas are freely and voluntarily made, and I will accept them. Mr. Israel Shavira Ortega, based upon your plea of guilty and the evidence now before the court, I am finding you guilty of driving while intoxicated, second offense, as charged in the information. I am following the agreement you made with the state, assessing your punishment at 51 days in jail and no fine, giving you credit for 51 days you've already served so that the sentence is taken care of and complete. I'm going to run 5 of those days concurrent to cover the court cost, waive the attorney's fees. I am going to assess the DWI traffic fine at $4,500, but then suspend that, finding that you have that you are indigent after having been in jail and not working for 51 days. I will order a driver's license suspension for 365 days, beginning today and ending October 12th, 2026, and order that you have an ignition interlock device installed on each vehicle owned or operated by you before October 12th of 2026, and to keep such a device installed on a vehicle for 1 year from that date, and to not operate any vehicle not equipped with an ignition interlock device during that time. Any questions, sir?
No.
All right, thank you. You may be seated. Luis Marmolejo Ibarra, based upon your plea of true and the evidence now before the court, I do find that you have violated community supervision as alleged in the motion to proceed with adjudication. At this time, I will adjudicate you guilty of the offense of driving while intoxicated, a Class B misdemeanor committed June 5th, 2021 in Lubbock County, Texas. Are both sides ready to proceed to punishment? State?
Yes, Your Honor.
Defense?
Yes, Your Honor.
I will follow the agreement you made with the state, assess your punishment at 50 days in jail and no fine. I'm going to give you credit for 62 days you've already served. Run one of those days concurrent to cover the remaining $55 in court costs, continue the finding of indigence, waive the attorney's fees, assess the DWI traffic fine at $3,000, but waive that, finding that you have been in jail and unemployed continuously for 60 days. And that takes care of, that takes care of everything. Any questions?
No.
All right, you may be seated. Christopher Perez Gonzalez, based upon your plea of true and the evidence now before the court, I will find that you have violated your deferred adjudication, and I will at this time find you guilty of the offense of driving while intoxicated with an open alcohol container, a Class B misdemeanor committed December 23rd of 2023 in Lubbock County, Texas. Both sides ready to proceed to punishment? State?
Yes, Your Honor.
Defense?
Yes, Your Honor.
I will follow the agreement you made with the state, assess your punishment at 60 days in jail and no fine. I'll give you credit for 42 days already served. I will run 8 of those days concurrent to cover the court costs, waive the attorney's fees, assess the DWI traffic fine at $3,000, but waive it because you have been in jail and unemployed for 40 continuous days. So you still have 18 days left to serve, unless you've got credit for good time or something. I wish you luck with all of that. If there's nothing further, then you may be seated and we'll be adjourned on your case as well. Is there anything further?
No, Your Honor.
No, Your Honor.
All right. Okay. Thank you, Maritza, and thank you, Richard.
Thank you.
All right. Maritza, did you have any others? I don't think so. She's gone.
No, that was it, Judge.
Okay. Lindsay Murray, are you ready on David Christensen?
Yes, Your Honor.
David Christensen, if you'll please stand. Let's see. Wait a minute. Let me ask all the remaining gentlemen to please stand and raise your right hand. I'm going to place you under oath. Do you and each of you solemnly swear or affirm the testimony that you will give in your matter now before the court will be the truth, the whole truth, and nothing but the truth, so help you God? If so, please say, I do.
I do.
Okay. For all of you, well, now some of y'all should still be standing. If you haven't had your hearing yet, still be standing, okay? Do I have David Christensen?
Yes.
Do I have Gregorio Rodriguez Tafoya?
Sir. Stand up.
Cedric Espinoza? And Craig Williams?
Yes, sir.
Okay, who's not standing? I only see 3 people standing. There should be 4.
You gotta
I
stand
think it's the Spanish speakers.
It's Gregorio, Your Honor. He seems to
Okay.
be complying with instructions very well. We might need to.
All right, well, let's see if we can get through this. If there's a problem, we'll take that up. Okay. Gentlemen, I've got this paperwork here that is the record of your pleas. It seems to have signatures on it. Is this your true and correct signature on each of these papers, gentlemen?
Indeed, yes.
Okay, I'm going to have to do this. I can't, either you all need to say yes at the same time, or I'm going to have to do you individually one at a time. And I need to hear you say it loud and strong. So, gentlemen, is this your true and correct signature on each of your papers?
Yes. Yes.
Did you sign them freely and voluntarily?
Yes.
Did you read and understand what you were signing?
Yes. Yes.
Did you understand that by entering into a plea bargain, you waive the right to remain silent, the right to a trial by a jury of your peers, and the right to make an appeal?
Yes. Yes.
David Christensen, did you understand that by entering into a plea bargain, you waive the right to a hearing before the court and the right to appeal?
No,
No, you don't understand that?
I didn't at the time, but now I do.
Okay, you do now.
I understand now what happens when you do that.
Okay, good. For everybody else except David Christensen, are y'all pleading guilty to something this morning?
Yes. Yes.
Are you pleading guilty because you are guilty and for no other reason?
Yes.
Okay. David Christensen, are you pleading true to the allegations in the motion to revoke?
I haven't heard what the allegations are.
Okay. David, if you'll be seated, I'm going to take these others up real quick and then I'll come back to yours since it's a little bit different. Okay. All right. Counsel, for the guys pleading guilty, are you satisfied that they are competent to make their pleas of guilty?
Yes, Your Honor.
Ms. Khan?
I'm observing Gregorio, Your Honor, and starting to have some questions.
Okay.
Yes, Your Honor.
All right. Greg, let me ask you, everybody except Gregorio, to be seated. Gregorio, will you come forward a little bit so I can see you closer to the camera? All right. Thank you very much. I appreciate that. Gregorio, can you hear me okay? Gregorio, can you hear me okay?
Sir?
He's got a big smile.
Okay, good. Gregorio, you are charged with evading arrest or detention, a Class A misdemeanor committed May 28th, 2025 in Lubbock County, Texas. That carries a range of punishment of up to 1 year in jail and an optional fine of up to $4,000. I have a recommendation here for you to plead guilty and be sentenced to 139 days in jail, which you have already served. I'm sorry?
Yes, sir.
Okay. Do you understand the charges against you?
Aye, sir.
Do you wish to accept the offer and plead guilty for the 139 days in jail so you have this done?
Yes.
Are you pleading guilty to that offense?
Aye, sir.
And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
Ms. Walcott, are you satisfied now that he is competent to make his plea of guilty?
Yes, Your Honor. Yes.
I will find that your plea is freely and voluntarily made, and I will accept it. Based upon your plea of guilty and the evidence now before the court, I will find you guilty of that offense. I will follow the agreement you made with the state. Assess your punishment at 139 days in jail and no fine. Give you credit for 139 days you've already served. Run 3 days concurrent to cover the court costs and waive the attorney's fees. So this is complete. They ought to be able to get you booked out on this now, and hopefully there's nothing else holding you. I wish you the best of luck, sir. We are adjourned. You may return to your seat.
Thank you.
All right.
Thank you, Your Honor. May I be excused?
Yes, ma'am.
Thank you, Judge.
You know, he's never been served that warrant.
I know. I'm gonna write it. Okay. And Professor McDonald, I just got the rest of the paperwork on Craig Williams, so it looks like we'll be able to get that done in just a minute.
Thank you, Judge.
Okay. Cedric Espinoza, would you please come forward and approach the camera? Thank you. Can you hear me okay?
Absolutely.
Excellent. I can hear you too.
Sir.
Cedric, are you pleading guilty to the offense of theft 100 to 750, a Class B misdemeanor committed November 7th, 2024 in Lubbock County, Texas?
Yes, sir. Absolutely. Yes, sir.
Oh, thank you. Are you also pleading guilty to a theft 100 to 750 Class B misdemeanor committed April 20th, 2025 in Lubbock County, Texas?
Yes, sir. Absolutely.
Are you pleading guilty to both of those because you are guilty and for no other reason?
Absolutely. Yes, sir.
Mr. Walker, are you satisfied Mr. Espinoza is competent to make his plea of guilty?
Yes, Your Honor.
I will find that your pleas are freely and voluntarily made. I will accept them. I will find you guilty of each of those theft offenses. I will follow the agreement you made in each case, assess your punishment at 16 days in jail and no fine, give you credit for 16 days you have already served in each case, run 4 days concurrent in each case to cover the court costs and waive the attorney's fees. So these are complete and done now. I do need to advise you this is 2 convictions for theft offenses. It disqualifies you from jury service. It can be used to impeach your credibility if you testify in a civil or criminal situation. And if you were to get another theft charge, no matter the amount of the stolen items, it could be enhanced to a felony called theft with 2 priors because of these prior convictions. Do you understand all of that, sir?
I understand that. Yes, sir. Absolutely.
All right. Good luck to you. We are adjourned. You may return to your seat.
Your Honor,
Yeah.
I'm sorry. There was just one more matter that I just needed to put on the record. My client also had an unfiled charge for criminal trespass. That's a PFM 2025 MAG 3970, and that was one that the prosecutor had said that would be rejected as part of this plea, so that my client can be done with the time served and be able to get out to this afternoon.
Mr. Hirasawa, can you confirm that?
Yes, Your Honor. I will take care of it.
Thank you very much. Thank you, Mr. Walker.
Thank you, Your Honor.
Thank you, Mr. Espinoza. You can return to your seat now. And if David Christensen would come forward, please. Miss Lindsay, we're ready for you. All right. David, you understand that you have a right to a hearing before the court on a motion to revoke community supervision?
Yes.
You also have the right to have the allegations in the motion read out loud to you. You understand that?
Yes.
If you understand the allegations in the motion and you're here to enter into a plea bargain, you have the right to waive the reading and to waive the hearing and enter into a plea. Do you understand that?
Can you repeat that?
If you understand the allegations, you can waive the reading of them out loud. And if you want to just enter into a plea bargain, you can waive the contested hearing before the court, and I can just take the plea and follow the sentencing agreement.
What is the what's the sentencing agreement?
The recommendation is for 180 days in jail and no fine, and you would get credit for the time that you've already served, which is well more than 180 days. So you would be done with this case today. We would no longer hold you on this case.
And then I'd be free to go when?
If you don't have anything else holding you, then they ought to be able to process you out today.
Okay, so would I just stay in processing until I got processed out?
That's a question for the sheriff. I'm sorry, I do not know their procedure on that.
Okay, can I have my handcuffs removed?
That is up to the sheriff. If they don't feel comfortable doing that, then no, I'm not going to order them to. Do you wish to proceed with this plea bargain today, or would you like us to reset it for a hearing, a contested hearing before the court?
And the court convened immediately, and we have a contested hearing right now.
Well, I don't know, but this is not a place for that. They haven't called the probation officer as a witness or any other witnesses. This was just scheduled for a guilty plea, not a contested hearing. We would have.
You would be let go, dude. It's kind of a no-brainer.
Have to reset it for a contested hearing.
What are they saying in the I don't remember the specifics about the case.
Okay, you pled guilty and were placed on probation for terroristic threat. You were sentenced to 180 days in jail. That sentence was suspended. You were put on probation for a period of 24 months. They're saying that you have violated that probation by not paying community supervision fees, that you owe $1,080 on that. And that on July 3rd, 2025, in Nueces County, Texas, you committed the offense of assault of a security officer. On April 25th, 2025, in Nueces County, Texas, you committed the following offenses: possession of marijuana less than 2 ounces, possession or delivery of drug paraphernalia, and public intoxication. On June 9th, 2025, in Potter County, Texas, they're saying you committed the offense of assault of hospital personnel on hospital property. They're saying that you've failed to maintain total abstinence from the use or possession of alcoholic beverages, narcotics, substances not meant for human consumption, cannabinoids, or dangerous drugs not prescribed by a physician, to wit.
You know what? I take it back. Just let him sit. He's already been in there over 180 days. He doesn't know what's going on. Let him do the contested hearing. It sounds like he needs a little bit more time anyways.
That the Corpus Christi police report indicates that you were arrested for public intoxication on April 25th of 2025. They say that you failed to report to the Community Supervision Office as directed for the months of May 25 and June 25, and that you failed to remain within Lubbock County, Texas, because you were arrested in Corpus Christi, Texas, and didn't have approval to leave Lubbock County, Texas, to go there. Those are the allegations in the motion to revoke. Again, if you are revoked, you could get up to 180 days in jail. Obviously, you have more time than that now. And so if you want to plead true to those allegations, we can get that done and you can be released on this charge. I don't know if there's anything else holding you or not. If you want to have a hearing, then we'll have to reset this for a contested hearing before the court where witnesses can be called.
So if I were to plead true to the allegations, I would just be pleading true to an allegation, not pleading, it wouldn't be a plea of guilt.
Okay, I cannot give you legal advice. That might be something that you need to talk to your attorney about what the ramifications would be if you plead true to the allegations here, as far as how that would affect another case somewhere else. Do you need to speak with your lawyer in private?
May I do so right now? Yes.
We can put you in a breakout room. Do you want to do that?
He just had a couple questions. We did discuss this yesterday. I think he is clear today.
Okay. Mr. Williams, Mr. Christensen, you've had a chance to visit with your attorney, Miss Murray. Has she been able to answer your questions?
Yes, she's giving me advice, yes, sir.
Are you ready to proceed?
Yes.
All right. Let me ask you, I have already kind of read the allegations in the motion to revoke to you. Do you waive any further reading?
No, what I understand from the reading of the reading is that there were some substances that I consumed that were not meant for human consumption that I consumed. And there was an assault that was alleged, and there was a public intoxication involved, which I'm guilty of the public intoxication. And pleading true to those allegations would incur a sentence of 180 days, which is already served here at this jail, which would mean that I would be released from probation and processed out, having done time served in this facility.
Okay, it sounds like you understand very
Is that
well.
correct?
That's my understanding. Yes. Okay, are you pleading true to those allegations? Mr. Christensen, are you pleading true to those allegations? Mr. Christensen, I need a verbal response from you. Are you pleading true to the allegations in the motion to revoke?
Yes.
And are you pleading true because they are true and for no other reason?
Yes.
Ms. Murray, do you find that Mr. Christensen is competent to make his plea of true?
I believe so, Judge.
I will find that your plea is freely and voluntarily made, and I will accept it based upon your plea of true and the evidence now before the court.
I am questioning the competency part. Just my observation, though.
I will find that you have violated the community supervision as alleged in the motion to revoke. I will follow the agreement you made with the state, revoke your community supervision, sentence you to 180 days in jail, give you credit for that time you have already served, run 1 day current to cover the court costs. This is complete and done. I've signed a bench order to let the sheriff know that you are done on this case. Good luck to you on everything else. You should be processed out on this case today. If there's another hold on you, you'll have to deal with that. I don't know that there is. So thank you, Mr. Christensen. You may sit down. We are adjourned. All right. Craig Williams.
Go sit down. So.
Good morning, Mr. Williams. Let me ask you to first raise your right hand. Do you solemnly swear or affirm the testimony that you will give in this matter now before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, you can put your hand down. Mr. Williams, the first thing I've got to do is arraign you on a new case. The state in CC 2025 CR 2404 has charged you with two things, evading arrest or detention and failure to identify by giving false or fictitious information. Offense is alleged to have been committed in Lubbock County, Texas, on or about June 24th of 2025. I'm going to enter a plea of not guilty for you at this moment, although I have a sinking suspicion that will change in just another minute when we do your guilty plea. You need to understand that you have the right to remain silent. You have the right to make a statement relative to the accusations brought against you. You cannot be compelled to make a statement. If you do make a statement, it may be used in evidence against you. You have the right to speak to an attorney prior to, have that attorney present during any interview with peace officers or attorneys representing the state. You have the right to terminate an interview at any time. You have the right to request appointment of an attorney if you cannot afford one. And finally, you have the right to contact your country's consulate prior to being questioned if you're not a U.S. citizen. Now, are you ready to proceed to a guilty plea on this new case and on the old case?
Yes.
All right. I have some paperwork here from you that appears to have your fingerprint, which is serving as your signature in these matters. Did you provide, is that your true and correct fingerprint?
Yes.
Did you provide it freely and voluntarily?
Yes, sir.
Did you read and understand what you attached your fingerprint to?
Yes, sir.
Do you understand that by entering into plea bargains, you waive the right to remain silent, the right to a trial by a jury of your peers, and the right to make an appeal?
Yes, sir.
Okay. In the older case, 2025 CR 2080, are you pleading guilty to failure to ID or providing false information, a Class A misdemeanor, while you're doing that while a fugitive from justice, a Class A misdemeanor committed August 16th, 2025 in Lubbock County, Texas?
Yes, sir.
In the brand new case that was just filed today, are you pleading guilty to count one, evading arrest or detention, and count two, failure to identify Class B misdemeanor, evading Class A, both committed June 24th, 2025 in Lubbock County, Texas?
Yes, sir.
And are you pleading guilty to all three of these because you are guilty and for no other reason?
Yes.
Counsel, Ms. Khan, are you satisfied Mr. Williams is competent to make his plea of guilty to all three charges?
Yes, Your Honor.
I will find that your plea is freely and voluntarily made, Mr. Williams, and I will accept it, and I will follow the agreement you have made with the state. In the older case, the failure to ID Class A misdemeanor from August 16th, I will assess your punishment at 59 days in jail and no fine. I'll give you credit for 59 days you've already served. Run 4 of those days concurrent to cover the court costs. There are no attorney's fees. You have this sentence complete. In the new case, I will assess your punishment at 1 day in jail on both count 1 and count 2, give you credit for that 1 day you've served, give you credit for the days that you had served before that to cover the court costs. There are no attorney's fees on that case either. So all of your cases are complete and we are adjourned. Good luck to you, sir.
Okay. Thank you.
Thank you, Mr. Hirosawa and Ms. Khan and Mr. Metz for getting all that done so quickly.
Thank you, Your Honor. May I be excused?
You certainly may. Good luck to everybody.
Judge, may I be excused as well?
Absolutely.
Oh, that was so much fun. I know somebody's got to go outside. I'm going to put something on for you guys to watch. It was really, really good. I have not edited it yet, but it's super, super good. I'll put it on and then I got to run her out real quick. Nana Laura, it's your favorite magistrate.
14B District Court is now in session.
Yeah, appreciate it.
Hi, can I have your name?
Daryl Gardner.
Okay, thank you.
Thank you. We're going to earlier.
You look back, I can roll it now. Now calling case number 13T00166. This is the Township of Ypsilanti versus Daryl Gardner. Can I have appearances for the record, please?
Good afternoon, Your Honor. Kelma Dadush on behalf of Mr. Gardner.
We are here today for an arraignment on a bench warrant. What I am seeing. Okay. So the last time you were in front of me, looks like was in April. You had your pretrial date adjourned out to June 9th. You failed to appear. It was adjourned out to July 7th. You failed to appear. A bench warrant issued for your arrest. You were arrested and you were arraigned by the judge on July 21st. She reinstated all of your bond conditions and set you for a pretrial on August 27th, and you failed to appear on August 27th. So here we are.
Yeah, like I told him, June 9th is my birthday. I never got no call saying I was supposed to appear on June 9th.
Well, let's the most important one to address is the last one. The last failure to appear, because you did see Judge Washington in July. So in August 27th, Your Honor, Mr. Gardner let me know that he was on the Zoom call, that he was waiting for hours and that his name that was not called, and that's why he left the Zoom call. He was not attempting to not appear at his court date, especially since he had seen the judge a month before. He is not trying to, abscond from anything here. He does want to show up and get this case resolved. We are not assigned on this case. We had to withdraw because of a conflict. I don't have many notes as to what happened, aside from what I see on my court and what Mr. Gardner tells me, but he did tell me that, he was on the Zoom for hours. Not sure if he left before there was a chance for his case to be called or if he missed it or something of the sort, but I would ask that he be able to be released. This is a 2013 case. It's incredibly old, which doesn't mean he doesn't need to be appearing on it and resolving it. But it is an older case. He does have another case that's holding him. He's being seen on that by the magistrate, but that's only a license case and it's a misdemeanor. And my guess is that he will get a PR on that. But since he hasn't seen the magistrate on that yet, I have no way to tell.
Can I speak up and, state a few things for the record? As far as I recall, the Zoom date, it might have been, I may have made a mistake. It might have was in July, but I was on there. And I know you guys got a record because my phone was in my name, my 313-764-6095. It was my name. So in order for me, it said on the Zoom thing, in order for you guys to know that I'm here, the device that I'm using had to be in my name. So there's a record that I was on there. I never absconded. I never attempted to run. I did what you guys told me, and they just had me sitting there for hours, just sitting there.
And I can understand that's a frustrating situation to be in, but that's how the judge does it with Zoom hearings. I mean, that's frequently how I do it too. Like, you wait in the waiting room and you are brought in when your case is being called. So if you leave You leave. That's on you. Okay?
What's the point in making me sit there 4 hours? You know, what's the point? Why can't we just do it in person like they do it in normal times and it can be done in 20, 30 minutes? I go to jail or I go free. You just got me sitting there looking dumb for 4 hours. I mean, come on, man.
Okay. So I have good news for you in that regard, and that is the court renovations are done and we'll be opening back up to the public. So I'm going to set your next court date for in person. Now, I will point out that coming to court in person, that can eat your whole day regardless. Like, you come to court, anticipate losing a day. That's just how it works. All right, we'll set you for in the morning, but your case gets called when it gets called.
What's the point in setting the time then? Why don't you just say when you get called? That
How are
way
they-
I know, you know,
Mr.
whenever.
Gardner, the court has no way of knowing who's going to show up and who's not going to show up, and they have a big docket. They can't give everyone a time. They don't know how long each hearing will be. That's just how any court system works. In Judge Simpson's courtroom, people stay there for 4 hours.
Don't you know the world revolves around him? Everything should drop and deal with his matters so he can be happy at all times. That's the way the world works, isn't it?
It is quickest for you, I'll tell you, to show up and get this case resolved rather than,
I've been trying to, man, because
I
I'm
know.
tired of this shit. I swear I'm just tired, man.
Cuss.
Every time when I'm saying, man, they keep arresting me, man. They keep throwing me in jail and making me sleep on concrete for some stuff that, come on, man. You want to keep me here, just keep me here and get it over with and just be done with it. But I'm not finna keep running from y'all, man.
I'm gonna ask that you watch your language, please, because I know it's Zoom. You are still in court. I can hear that you're very frustrated. I'm gonna set you for another court date that will be in person. All right? Show up for court in person and you'll be in good shape, okay?
Be there. I'm tired of this stuff, man. I'll definitely be there. I told you back in April I'll be there. They never informed me of a June 9th court date because I would have told them, yeah, man, you can, for the record, don't take this the wrong way. But if they
No,
would
I would just let the judge give you the next court date and hopefully give you a PR bond. I don't think what you're saying is going to help you further.
it wasn't.
Hey, everybody. Okay, thank you. So what I'm gonna say is if you get a phone, because right now I don't have a phone number for you. If you have a phone with a good phone number, you can get signed up for text message reminders. But other than that, you'll get paperwork when you leave the jail. If you lose the paperwork, forget your court date, whatever, I'm gonna give you another court date. You're gonna know that you have one coming up at 14B. If you can't figure out when it is for whatever reason, you can call the public defender's office. You can call the 14B district court, okay, to get your next court date. But I'm gonna give you it right now. Township. November 19th.
Next court date.
That's gonna be your next court date, November 19th, because that's, we're gonna be open in person. Okay, so you're gonna be in person in front of Judge Washington.
All right.
That would be
prefer it that way.
What was that?
Say I prefer it that way in person.
Okay.
So that way they'll know for sure I showed up.
Yes. I can appreciate that. Okay, so November 19th, 9 a.m. in person in front of Judge Washington. And that's at the 14B District Court.
All right.
Yeah.
So I gotta sit in here until the end or
No. Just give me a sec.
Yeah, that's pretty accurate. They have chain link fences and it's crowded. It's hot. Yeah. People take for granted how nice the US prisons and jails are, for real. There's a lot that's taken for granted. I'm getting love bit.
Do you have reliable transportation?
Yes.
Hey.
Okay. Are you employed?
No, no, ma'am.
Your Honor, he was employed. I believe he just lost the job. And he's looking for alternate employment right now. Correct, Mr. Gardner?
Yes, ma'am. No, actually, I'm not able to work right now due to this, but what I can do with my one hand, no, it's not much I can do right now.
Attorney Dadush, do you know who was appointed?
Yes, Damian Cash.
And Mr. Gardner, have you been in touch with this Attorney Cash?
I don't think so. I was in touch with I can't remember her name. She was
I think he had Ashley for
yeah,
arraignments.
her. Yeah, I was in touch with her after I left here in April.
Okay. So it sounds like that was potentially part of the issue too. Because the public defender's office, it looks like, withdrew from your case, so another attorney was appointed. Okay, I do have that. So, yeah, his name is Damian Cash.
Okay.
All right. So, if you haven't spoken with him,
I think I might have did speak with this guy.
okay. Well,
Yeah, that was when I had my job. Yeah, I had my job. I was staying with my sister then, but that was months ago. I don't even recall anything we talked about. I'll be honest with you. Yeah, with a name like Damian Cash, you would think it would stick out in my mind, but I don't. I'm not for certain if I even talked to this guy or he might. That's what he might have talked to my sister. He might have talked to my sister or something. I don't recall conversation with no Damian Cash. I spoke to Ashley. I spoke with her several times.
okay. Thank you, Mr. Gardner. I got it. So you need to speak with Attorney Cash before your next court date, all right? And the contact information should at least potentially be on your paperwork that you're gonna get when you leave today. Okay?
Okay.
Advise and contact the public defender's office so you can get the contact information from them.
You say November 19th,
Yes.
9 o'clock. You start what time?
9 o'clock.
All right.
And I think it's starting to set in with him. This is all his own doing.
All right. So at this point then, you've got your next court date, November 19th, 9 a.m. That's in person at the 14B District Court.
Ma'am.
And I can tell you right now, just with the
Where is 14B? Is that downtown Ipsy? Across from
it's Ypsilanti Township. Okay, so it's the one off Whitaker Road, South Huron River Drive, you know where the Whitaker Road
yeah,
is?
I know where that's at. I can ride a bike to there. I know where it is.
Okay, yeah, the one with the pond out front.
Mhm.
Be
Okay.
careful riding your bike in November.
Why? Snow.
Like it could be icy. Just be careful. You already had hurt your arm.
Yeah, I'll figure it out. Oh no, the bus goes out there too.
Does,
The
yes.
bus right out there.
Yeah,
Yeah.
and actually there's a bus stop right in front of the courthouse.
Mhm.
Okay, so if you fail to appear on this next court date, I'm not gonna be inclined to do another personal recognizance bond,
Man,
okay?
you got on my mother's soul. I will be there, man. I promise you, I'll be there. I'm tired. I'm so done with this.
Okay.
My mother's grave. I will be there, man. I swear, man. I just want to be done with this crap. Promise you, I'll be there.
We will see. Okay, so and that is gonna be
You'll see. I'm going to come.
okay. All right, good. That is what I am looking for you to do. Okay, so personal recognizance bond, $50,000 personal recognizance bond. So if you don't show up, then your bond's going to be at least $50,000. Okay. So
What's the backup?
what was that?
Sorry, Your Honor. What was the backup?
50.
50? Okay.
Yes. So yeah, the judge currently has it set at 20. I'm gonna grant a PR, but if you fail to appear, it'll be 50. And you understand what your conditions are, okay? So that your conditions haven't changed. You're not to leave Michigan without permission. You're not to have any weapons, etc., etc. Okay, do you need me to go through them all again?
Oh man, stay away from I know them all.
Okay. All right. So you've got your next court date. You know what you're doing.
Mhm.
See you on November 19th. Okay.
Thank you.
Okay, thank you. Then, Mr. Gardner, you're free to go to the door.
Thank you.
Okay, thank you.
I need
Magistrate Braley, I
What
think there's some, I don't know why your voice is a bit low. When I was seeing it earlier, I think a lot of the clients were talking over you. We can't hear you super well. That may be why people are kind of talking over you.
Great, because I've got no idea how to combat that aside from screaming. So,
sound fine here.
I'll try to stop the client if I see, if I see you talking, I'll be like, let the magistrate talk.
that, and I will try to speak up.
I need to go get Ava in because it is raining outside. So I'm going to let this run. I don't know. Like I said, it's unedited. I have not gone through any of it. So I have no idea what we're going to see. I saw little bits of that case when I was acquiring it. So I knew that one was good, but the rest is mystery. But I have to go grab Ava and then I'll be right back.
I'm still stretched out. I don't know what's.
Sorry, give me just a moment. Did you have it on this meeting or did you not? Good afternoon. Can I have your name, please?
Good afternoon. My name is Amber McCullough.
And so Ms. McCullough, you're aware you have a handful of bench warrants? Were you aware that you have a handful of bench warrants?
Yeah, did you say, am I aware I have bench work? Yeah, yeah. My attorney, yeah. Unfortunately.
That's what the whole zero lot now.
Yeah.
Now calling case numbers 17T00139, 20W002117A and B, 15W000431A, and 06W171797. Okay, excuse me. 06W171797B and 06W171997C. Those are all the matters of Amber McCullough. Can I have appearances for the record, please?
Kerma Dadush on behalf of Miss McCullough. I don't know why I have different case numbers. What was the last one you said, Your Honor? The BC ticket?
Well, there's two different BC tickets. So one of them ends in 1797B, and then there's one that ends in 1997C.
I have two completely different case numbers. Is one of them an OWI and one of them is a traffic citation, the failure?
No,
I think the other.
Okay. Do they start with like DIB or something?
No, one of them is 20W 00217B, and then the other one's 17T-00139.
Yes, those were the first two that I called.
Oh, why did I have different numbers that you called? Okay.
Okay, no, that's because there are 4 citations, and then the matter ending in 117B, there's a bench warrant.
Okay.
And the matter ending in 139, there's a bench warrant.
Okay, gotcha. Thank you, Your Honor.
Okay, so we are here specifically for arraignments on the matter ending in 139 and 117B. What I am seeing is that bench warrants issued for your arrest in these matters back on January 25th of 2023.
That sounded awful confusing. I missed the majority of it because I was getting Ava, and when I brought Ava in, of course, Billy and Tiny both ran out, so I will have to rescue them from the rain shortly. But yeah, I came back to a mess.
It looks like you failed to appear for a court date in front of the judge. There was also a violation of probation requested on the matter ending in 139. And the allegation there is that you failed to drug and alcohol screen as you were ordered to do, and you failed to contact probation for over 90 days. So, Attorney Dadush?
Your Honor, I did talk to Miss McCullough about both of these cases. She let me know that she has just been going through a lot. She has 4 kids. She has one who's in her care and then takes care of a grandchild. She has a full-time job at McDonald's. She works night shifts, and sleeps through the day. She just had a lot to take care of. She was not intending to abscond. I believe she also has a lot of cases going on. So it was confusion regarding what cases she needed to go to. She also let me know that I believe she said she appeared for a Judge Simpson case that was the same time as another case that she had. I let her know that if she ever can't make it, to at least contact her attorney so we can share that with the judge on her case. If she can't appear, if she needs it's better than her getting a bench warrant instead of us having any idea where she is.
Everybody's going through a lot. You're going through a lot. I'm going through a lot. Hell, Ava's going through a lot. That's not an excuse. That's never an excuse. I understand being overwhelmed with life, but you gotta deal with your crap. And if it's a situation you caused by committing some type of a crime, you're making your own life harder. It doesn't have to be.
Miss McCullough, did you want to speak to it as well? You don't have to if you don't have anything to add.
No.
She also has, unfortunately, as you already know, Your Honor, other things that are holding her. Driving with license suspended, failure to stop out at a scene of a property damage, and then drug paraphernalia misdemeanor possession case. She's being seen on those at 1 p.m. I don't know the possibility of her being released on those. I would ask for a low cash bond so she can get credit for time served, potentially to convert to a PR if she's released on those other matters. She's also being seen on a 15th district court case tomorrow, driving with license suspended. Most of these are old cases, as you probably already know, except one driving with license suspended from 2025. She is employed. She has been a manager at McDonald's for the last 8 months. And as I mentioned, taking care of one of her children and then a grandchild as well in her care.
Perfect. She's probably screwing up the next generation. This is why I edit.
No matter what else is in the world right now, will make. Now and then, coming to this time. So, that's-
What I am going to do is set a hearing date for the violation of probation. That will be December 2nd. That will be in person at the 14B District Court at 10 a.m. That will be in courtroom 1 in front of Judge Washington.
I don't know if we're gonna have Michigan for long. I don't know if once they go to in person, we may never see them again. Thank God for the archive drive.
I am reinstating all of your prior conditions. So any sort of testing or anything that you were ordered to do, you need to test.
Okay.
Prior to your release, you're to be fitted with a sober link. That's something that you take with you. You breathe into it a couple times a day and it tests you for alcohol.
I've never, I'm gonna tell you out of all I've never, I don't drink at all. So is there a particular reason for, I mean, I don't drink. For a silver link, I've never had a problem with the alcohol because I literally don't drink at all. I don't even like alcohol. The OWI that I got in the first, it was very low. I had like 2 drinks and I ended up getting pulled over and my friend happened to be drunk.
Miss McCullough,
Yeah.
I wouldn't talk about the details of the case. I think what you've said is enough.
I mean, I get it. I kind of rethought that because I guess it is an OW, but it was just an unfortunate situation.
Well, so you'll be seeing the judge on December 2nd, and at that point, she may decide to remove the sober link.
Okay, what is a silver link?
It's a thing that you take with you, you breathe into it, and it tests for alcohol.
Okay, so kind of like, okay,
It's not a
just a little machine.
Yeah, it's just, it's, yes.
Okay,
There are straws that come with it and you breathe into them.
okay.
Your Honor, I would ask about the timings since she works night shifts.
I work from 10 to like 6 a.m.
And do you sleep after that?
Yeah. I mean, when I get off work, yeah.
So it's from 6 a.m. to 9 a.m. in the morning and from 6 p.m. to 9 p.m. in the evening, but you can talk about that with the tether agent as well. Okay.
Okay, so that means I wouldn't have to go to the community corrections building to do that.
So they're going to come to you to get you the silver device. I do
Okay.
want you to go to community corrections within 24 hours of your release so that you can also drug test.
Okay,
And I want you to call the 14B District Court Probation Department within 24 hours of your release so that you can see what else they want you to do to get back.
okay.
Community corrections is right outside the jail. She's that correct, Magistrate?
Yes.
Yeah, so Miss McCullough, if you get released today, community corrections is right there. Ask the jail staff where to go for that, okay?
Okay. But don't I have to wait for the silver link machine or
Well,
whatever?
they're not gonna release you until they get you that, I believe.
That's what I mean, so kind of wait for that.
Very, very younger. There, I got one return.
What I'm going to do then is set bond in the amount of $1,000. 10% is allowed, and that may convert to a personal recognizance bond upon your release on the other matters.
Okay,
So your next court date, and this is for everything. So all of your stuff is going to be seen again together in front of the judge.
Okay.
December 2nd, 10 a.m. All right?
okay. So this will be a PR if my other cases give me PR.
Yeah.
Okay. Thank you.
Thank you. All right. If you don't have any questions, then you're free to go to the door and tell the jail that you're finished.
Okay, thank you.
Thank you so much, Manuel. You are so amazing, always putting up that reminder. We'll keep him for now. For now. I bet you did, Jerry. I bet you did. Jerry's over there cuddling with the like button, so anybody who wants to hit it, they gotta go through him.
Good afternoon. Can I have your name, please?
Sequangela Middleton.
I'll be with you in just a moment.
Things like that.
What you doing, Judge? Magistrate? What you doing? Bet she's probably reading past history or checking the PC or something.
Now calling case numbers 14S00159 and 15S00710. These are the State of Michigan versus Sequangela Middleton. Can I have appearances for the record, please?
Thank you, Your Honor. Can Madadush on behalf of Ms. Middleton?
Thank you. Today is the date and time set for arraignment in these matters. What I am seeing is that bench warrants issued for your arrest on September 18th of this year. That was after you failed to appear for a court date in front of Judge Washington.
Your Honor, I talked to Ms. Middleton about this case, all these cases. She let me know that she had just been at the hospital, sick with pneumonia. She said that she did text and talk to whoever it is at our office who was talking to her at the time. I believe that was one of our, either an intern or paralegal. I don't see a note in the file regarding that. But Ms. Middleton does have medical documentation she can provide the court regarding her pneumonia. I believe she said that she did. She has not had a failure to appear on this case for a while. She has been appearing on it since 2016, I believe. Has not missed a court date. Yes, it's taking her a bit long to make the payments, but she is making progress. She was appearing to let the judge know her situation. She wasn't really failing to appear in the past. She was just sick, and that's why she failed to appear during that date. So we would ask that she be released on her own personal recognizance. She has nothing else that's holding her besides these two cases.
Okay. Just to be clear on the 2014 matter ending in 159, that she just owes money on. For the matter ending in 710, she has not successfully gotten through a pre-trial all the way. So So Ms. Middleton, you do have documentation?
Yes.
Yeah, right. I got a lot of people that they put a lot of people that.
I really wish sometimes that we could make out what they were saying in the jail behind the door. Sometimes it sounds really good, and I'm just a nosy bitch. Read faster, Judge. Magistrate. I don't know how
How
long.
did you come to be in custody?
I was riding with a coworker, and she apparently didn't have any proof of insurance or something like that. So the police officer pulled us over and then asked for my name. And at the time, I didn't even know I had a warrant for Washington County. Wayne County was the one that actually pulled the car over, and then I was transported here last night. So I work in Wormley, so I was on my lunch break.
All sounds so inconvenient. How dare they? The company can't run without her. She has to get back to work. I think you're late.
That will give them next.
This time, the court will set a pretrial conference date in the matter ending in 710. That's going to be December 11th, 2025. That would be at 9 in the morning in person at the 14B District Court. So, I'm going to set a show cause hearing in the matter ending in 159. That'll also be December 11th at 9 a.m. Keeping them together.
Okay.
Regarding the matter ending in 710, you are to provide documentation of the hospitalization.
Okay.
Okay, you can provide it to the.
When do I have to turn it in?
Say that again.
When does it have to be turned in, the documentation?
Okay, so get it in before the next court date. Get it to the public defender's office or to the 14B district court or both. Both would probably be best.
Okay.
You do not have very much time to fabricate the documents, so let's hope they're real.
Okay.
Before December. Okay.
Yeah, your next court date is going to be December 11th.
Okay.
Will grant a personal recognizance bond. It's the judge currently has your bond set at $25,000. Going to grant a personal recognizance bond in this instance because you have the documentation of the hospitalization. If you fail to appear on December 11th, then a bench warrant can issue for your arrest again. Your bond could be revoked entirely, but at a minimum, it's going to go right back up to the $25,000.
So on both cases, I'm getting a personal bond?
Yes.
Okay. Thank you.
If anything is going on, you need to keep in touch with the public defender's office.
Okay.
The court doesn't know what's going on. And when that happens and you don't show up for something, bench warrants issue. All right?
Okay.
Okay. December 11th, 9 a.m. and that's in person.
Okay.
Okay. Any questions?
So the lawyer that I was in touch with that said that they called and I didn't answer, he has the information about me being in the hospital. I sent it to him.
Okay, just I again, I don't have it in the file. I don't know if it was an intern that you were talking to. I don't think your assigned attorney is a female, a male. I think it was a female. So you were most likely talking to a legal assistant or a paralegal or an intern. So just get in contact with the public defender's office when you leave, today or tomorrow. Tell them, I don't know, where this went, or go through your text messages. I don't know if you still have them.
I still have them.
Yeah, if you have them, ask the name of that person and then call the office and ask to talk to them. That way you're able to just get it sent to the attorney and ask for the attorney. They are moving around some of the attorneys now, so but as long as you send it, I would just go ahead and send it to the court as well. Okay?
Okay.
Just to be safe.
Okay.
Okay. If there's nothing further, then Ms. Middleton, you're free to go to the door.
Thank you.
Thank you.
Thank you, Your Honor.
I wonder if she's related to Judge Middleton in any way. I mean, it is Michigan.
You're welcome.
All right, do whatever reading you got to do now, Your Honor. So when the next person comes in, you're ready, and we don't have to sit through you reading files. Just read it now. I love her, though. But there are really long pauses in her docket.
Are we there?
Yeah, you're here. She looks fun.
Hello, can I have your name, please?
Larissa Jordan.
Okay, thank you.
I need to go get the kitties, or at least see if they're ready to come in. I'll be right back.
Now calling case number 25S00437. This is the state of Michigan versus Larisha and Jordan. Can I have appearances for the record, please?
Yes, Your Honor, Karima Dadush on behalf of Ms. Jordan, and we are going to be requesting that the charges be formally read on the record, please. I believe the other ones had been read to her, but now that the charge is reduced, correct? It'd be a different, was it a reduced charge or was it just moved between magistrates?
I'm not sure.
Well, I thought it had been a higher charge and was reduced. So in any case, we'd ask that the charge be formally read on the record, Your Honor, please. Thank you.
Thank you. So what I have here is a misdemeanor complaint that charges that on or about October 13th of 2025 at 2417 East Ellsworth Road, you did attempt to commit the following listed offense, and in the attempt did act towards the commission of that offense, but failed in the perpetration or was prevented in the execution thereof, to assault, batter, wound, resist, obstruct, oppose, or endanger Deputy Trent Sims, a sheriff or deputy sheriff of the county of Washtenaw that you knew or had reason to know was performing their duties. This is otherwise known as attempted assaulting, resisting, or obstructing a police officer. It is a misdemeanor with a maximum potential penalty of up to 1 year in jail, a $1,000 fine plus court costs or both. Do you understand all of that?
Yes, ma'am.
Okay, thank you. Count 2 charges that you did while Sally's Beauty Supply was open to the public. Steal property of the store that was offered for sale at a price of less than $200. This is otherwise known as third-degree retail fraud. It's a misdemeanor with a maximum potential penalty of up to 93 days in jail, a $500 fine, or a fine in the amount of 3 times the value or difference in price of the property stolen, whichever of those amounts is greater, plus court costs, or both the jail time and the fine. Do you understand all of that?
Yes.
Thank you. So you do have the right to remain silent. Anything that you say out loud or in writing can be used against you in court. You have the right to be presumed innocent beyond a reasonable doubt. You have the right to a trial by judge or by jury. You have the right to be represented by an attorney during all stages of these court proceedings, that is before, during, and after trial. You are not required to disclose citizenship status to the court, but you do have the right to consult with an attorney to see if this case would have any effect on your citizenship status. And if that part doesn't apply to you, don't worry about it. So, do you have any questions about your rights?
No, Your Honor.
Okay, thank you. Then, Attorney Dadush, did you want to address bond, please?
We do send you to the charges, and Your Honor, we are going to be requesting a personal recognizance bond. Miss Larisha Jordan is currently I'm sorry about that. I'm like going through the we were going to be asking for a personal recognizance bond. I'm just trying to see here if there isn't anything else that's holding her. Yeah, Your Honor, there's nothing else that is holding her currently. She has another misdemeanor that she has already, I believe, posted bond for. Is that correct, Ms. Jordan?
Yes.
But there is nothing else that's holding her. We talked about, or she talked about with the other attorney, regarding the no go-to order that she'll most likely get, and a no contact order. And she will be complying with all of the court orders that she gets. So for all of these reasons, we're going to be requesting a personal recognizance bond.
Thank you.
I can't believe the kitties didn't want to come inside. It is raining. They probably just didn't want to run through the rain to get inside. They're hunkering down in someone's garage, I bet.
Court is going to set a pretrial conference date that will be November 13th, 2025. That will be at 9 in the morning.
Last of the finger Albert off the court, going off to go.
Correction. That court date will be November 20th. That will be at 9 in the morning in person at the 14B District Court. That would be in front of Judge Washington in courtroom 1. The court will set bond with the following conditions. You are not to use or possess alcohol, marijuana, or illegal drugs. State of Michigan without the court's permission. You are not to purchase or possess any firearms, ammunition, other dangerous weapons, or the means to create them. Any weapons that you do possess are to be surrendered. You are not to go to any Sally's Beauty Supply locations. The court does not care if for some reason you are personally invited to go to one. Do not go. You are not to engage in any sort of assaultive behavior. You are not to engage in any sort of criminal activity whatsoever. You are to appear for any and all dates set free by the court, the next one in this matter being November 20th at 9 a.m. in person at 14B. Prior to your release, you are to be fitted with a GPS tether for home confinement purposes. You may leave to go to work, court, and to take your kids to and from school.
Oh, she didn't like that.
You understand all of the bond conditions. Okay, you're being recorded. I need you to actually answer.
Yes, I know.
Okay. These conditions will be entered into the Law Enforcement Information Network. They will be readily accessible to any police officers that you may come into contact with. And if they have probable cause to believe that you have violated one of these conditions, they can arrest you on the spot and you'll be held for a bond violation hearing in front of a judge who may revoke your bond and set a new, more restrictive one. At this time, the court will set a $10,000 personal recognizance bond. So what that means is you are not required to pay anything to get out. Basically, you are promising to appear for your next court date and to abide by all of the bond conditions. If you fail to appear or violate any bond conditions, then a bench warrant can issue for your arrest. Your bond could be revoked entirely. At a minimum, it would start at $10,000. Do you have any questions about anything I just said?
No.
Okay. Attorney Dadouche, did you have anything that you wanted to add? Okay, I'll take that as a no. Then,
Sorry, I'm muted because they're doing construction and I don't know what they're doing in the next door, but I said nothing further, Your Honor. Thank you.
Thank you. So, Ms. Jordan, if you don't have any questions, then you're free to go to the door and tell the jail that you're finished.
I was expecting a little bit more of an outburst there. She held it in pretty well. I was somewhat surprised.
That's that property, it's not our property, it's the road property. That we're- I'm in this one. Yeah, you're in this one. They told me somebody.
Good afternoon. I'll be with you in just a moment.
Don't make him wait. He might be like that other guy and feel the world revolves around him.
What's your name?
Jenkins, Sean Jenkins.
We don't have any.
S416635 This is the state of Michigan versus Sean Jenkins. So you are in front of me today for a show cause hearing. You were last in front of me on July 1st. You were in custody at that point as well. You know when you're getting out?
No, ma'am. I mean, no, Your Honor.
Thank you.
I want to know who that loud person is behind the door. I think we got muted. Why so serious? Lighten up, Judge. I know I do. So tonight, do you guys want us to finish that Sherrick Sav sit? Or should I try to find new stuff? Different stuff? The Sav sit in Judge Wolf's courtroom. There's 2 hearings that I have. We can do that. We can finish him. Yeah. All right. I'll put him together. That's what we'll do tonight. Oh, come on. These pauses drive me nuts. But every time I try to fast forward, even just a tiny, tiny little bit, then it like goes too far. Because apparently by the time I get so impatient that I try to fast forward, that's when they decide to talk. I don't know. I gotta get it edited. Shouldn't take long for the editing because I know, what I'm going into, and she's reading the probable cause statement and the officer statement and everything and his history, and she gets all her ducks in a row before she calls the case. Yeah, exactly. I mean, it's not bad. Can't fault her for it. She's gonna start now calling the case of I helped you out. Just finish my statement. Now calling case number. Oh,
Excuse me.
most likely. I'll shoot for a little earlier, but
Hey, Mr. Jenkins, I do not do this particularly frequently, but given the wide variety of very serious things that you are currently being held for, and the fact that you've been in custody for over 500 days at this point, I'm going to waive the fines and costs in this matter and close this ticket out.
Thank you, Your Honor.
Welcome. You're free to go to the door and tell the jail that you're finished.
Thank you. Have a good day. Yeah.
you guys are awesome. Thank you so much.
You ready to go back to it? All right. You wanna go back to it?
I was just talking that tonight, we're gonna watch the other 2 hearings of the Sav sit in Wolf's courtroom. Yes, thank you. You guys are amazing.
White and Mary.
Hi, can I have your name?
Ernesto Zuniga Alvarez.
That's the best. Hi, P+7. Oh my gosh, you guys are so cool. Thank you so, so much. We're watching Magistrate Braley unedited for her in custody hearings because the first one was a real banger. Hello, Wire Mother. Viximo1, so good to see you. Thank you, Kimby63. Love to have you though, Abby. Thank you so much. Oh, I don't know. I'm just happy you're here. Thank you. Oh yeah, that's all I see her do, really. Sometimes she does landlord-tenant ones, but I don't. She pretty much just resets them over to Judge Washington, so there's not really much there for them. And every once in a while, I'll get her doing civil stuff. Holy cows, that jumped quick.
Now calling 22W004900B. This is the Township of Ypsilanti versus Ernesto Zuniga Alvarez. You're here for a show cause hearing. You were last in front of me in June, and you were based on my note here if you were in custody at that point or not. It looks like you have a court date coming up on the 22nd. Okay, thanks. Last time I saw it go.
We had that earlier. Lots of it. Oh my gosh, I've been on for 3 hours. The
I'm going to
first
set you for a follow-up date, January 6th.
couple hours, they were
And
bad.
9 in the morning, in person, in front of me at the 14B District Court. Unless you're still in custody at that point, which, hopefully you won't be by that point, but we will see. Okay?
They already told me that I'm gonna be sentenced to 2 years.
Did they?
Yeah.
Okay, that does change things.
Has 751
I've been in here for 11 months.
I am going to do right now is this.
Yeah, I go live almost every night at around 11:30, 11:45 Central Time. Pretty much people find me when they get up to pee in the middle of the night. And they load up
I'm going to
YouTube.
keep that court date. I'm keeping it a Zoom date. And I'm going to look into that because at that point you'll have been sentenced and I'll be able to actually look things up and confirm them. Okay, so for now, it's the January 6th at 9 a.m.
All right.
Thank you, and we'll go from there.
Okay.
To the door, okay?
Thank you.
Thank you.
See you at.
Yeah, I don't really walk the dog. She fights with my walker.
That's all right.
That's it. I do need to see X. Yeah. I mean, I have one more person after you, Mr. Alvarez, but you're done.
Okay.
Yeah, there's also a Discord, and every time that I post a live stream, since YouTube really isn't great about notifying people, I put it on the Discord. So I'm gonna quick grab the Discord link so anybody that wants to join can join. And then you'd get the live notifications.
I've got Mr. Epps coming. It's gonna be 1 minute.
Okay, thank you.
Oh, come on, Mr. Epps. All right, popping into the Discord quick.
Back again? Hopefully last time though. I'm sure it's been over a lot of time. Have a good day, man.
Normally, I edit everything that I stream, but I showed everything that I edited, and then I wasn't ready for the fun to be done. So I was like, okay, let's throw on some Magistrate Braley. There's the Discord link. Hi, Army Brat 1964, sweetie. Yeah, Biggins a sweetheart. That would be amazing. Ava. Oh, hi, Earl. This is Earl. Ava, come meet the new people. Everybody, this is Ava. Come on. She's wet because it's raining outside and she had to go out. He's my baby. Best puppy dog ever. She's addicted to Blue Buffalo. Blame the channel because they're the ones that send it to her. And then there's 4 cats. Billy O.T. and Tiny Kitten Esquire are outside right now. And Earl Grey the cat is the one that meowed. He's Earl. Psst, psst. He's in the living room. And then
this is our last one, and it's a show cause hearing, so you may be excused. You can also hang out if you want to.
And Bandit's in her room. Bandit has her
Sorry,
own
could you
room.
repeat that?
I said this is our last one.
Okay.
And it's a show cause hearing.
Okay. I may just hop off then. Thank you so much.
Okay, thank you.
Do you know when I don't know if that's like published yet, when the courtroom's gonna be in person? I'm just curious.
So yes, I can talk with you about it offline.
Okay. Oh, sorry, I forgot. We're not off the record yet. Right. All right. Have a good, lovely day.
Okay, thank you.
Thank you.
Oh, he's a
Well,
cat.
Mr.
So.
Epps,
How you doing, ma'am?
I am here. So there we are.
So does Tiny Kitten Esquire.
All right. I was just taking a look at your case because we've been doing this for a little while now, I think.
Yes, ma'am. Is no way I can get time served for this offense?
So there's civil infractions. You can't get time served on civil infractions. But what I'm
Okay.
So at this point, it looks like you've already been in over a year. You've still got an MDoc hold. I don't know if that means they're transferring you over there or what.
I got a pending case too that I'm still dealing with.
Okay. So just a second. The possession case, you've got a court date on October 28th.
Yes, ma'am.
Given the age of the tickets, how much time you have already spent in custody, and the fact that you are facing yet more time in custody, I'm going to do something that I don't usually do, but yet I'm doing for the second time today, and that is waiving the fines and costs and closing out the tickets.
Thank you. I appreciate that, ma'am.
Well, you are welcome, and you are free to go back to the door and tell them that you're done.
Okay, you have a blessed day.
Okay, thank you, you too. And I believe that concludes our docket for today.
And it does. They really are. Oh my goodness. Yeah, so yeah, Bandit's in her own room because Earl and Bandit don't get along very well. Earl will be moving at some point as soon as my daughter gets her college apartment situated, but that could be a while. But yeah, those are my babies. And they are spoiled rotten. Yeah, so I will be back on tonight, guys. I am yeah, I am. I'm a single crazy cat lady. Earl and I talk all the time. He will come to me in the kitchen or in here and he'll just start meowing, and he gets mad if I don't meow back. So there's that. And then Tiny Kitten Esquire actually says, I love you. And he'll say mom a lot. It's like a toddler. If I'm trying to, do dishes or something, he will figure 8 around my legs going, mom, mom. Yeah. So it is, I wouldn't say I've always been a cat lady. I've always attracted stray cats. It's my superpower. But yeah, so I ran 2 hearings with this Sharik Vaughn out of Judge Wolf's courtroom, and I have 2 more that I'm editing and gonna run tonight. So he's a Sov Sit adjacent. Pro se, thinks he knows everything, and he thinks he's God's gift to women. So the previous 2 hearings, they're called Cray Cray Pro Se, and they're in the live streams. So if you want to watch them to get ahead of it, go ahead. And I'll be back on tonight around 11:30, 11:45-ish. So yes, I'm a night owl. So I am so, so happy to have you guys here. This is amazing. I really appreciate it. Oh, thank you. I just thought it was because I always have cat treats and pets. I grow catnip, so they're attracted to that. I get and I get a possum that comes around here all the time. I got to pet it once. Yeah. Raccoons every once in a while, but I don't pet them. Oh. Yes, thank you guys so much. And thank you, Biggin. That was just the sweetest thing you could have done for me. I can't tell you how much I appreciate you. They just got lots of teeth. They actually make really great pets, possums and skunks. Like, possums eat the most ticks of any animal. So I absolutely want them around my property. Because, yeah, even though she gets Simpiacaro, I still like to have as much tick protection as possible. And especially there's a new kind of tick invading the Midwest right now, and it reproduces rapidly. So, yeah, you can come up and get it. Earl left you a little treat. So yeah, possums are great for tick protection. Skunks, if you have their scent sac removed, they actually make better cats than cats because people are less allergic to the dander of skunks than they are of what did it get on my shirt? Get out of here, weirdo. Me too. Me too. And squirrels. Oh my gosh, I love squirrels. Yeah, I love all animals. I really do. They're the best friends. And then you guys. You guys are also my best friends. So, thank you so much. Oh, they love cat food, dry cat food. So, if you want to, you can just put out a little bowl of dry cat food, and they love that. Yes, they're so sweet and cute, but they have such energy. You have to be able to play with them, and like, yeah, they're oh, they're so sweet. Exactly. Yep. The only true unconditional love comes from animals and people with Down syndrome. I'll take that one to my grave. People with Down syndrome, they don't know anything but love. They are amazing. All right, guys. Thank you so much, and I hope to see you guys tonight. Like I said, if you get up, go pee in the middle of the night, I'm what you're going to find on here. So be safe, be well, sleep sweet, and much love.